my friends, and thank you to all of you who teleported over from the morning. A couple hours we were covering the testimony from the Colorado case, the Boulder horrific supermarket massacre from March of 2021, in which 10 people were murdered by a 21-year-old gentleman who is now claiming insanity and schizophrenia made him do it. We're going to see if that case winds up, if the jury ends up accepting his defense of insanity, his untreated schizophrenia. So glad you're here with me. And in Small World Stories, if you haven't been watching that trial with us, come watch it. It's fascinating. It is quite honestly one of the best prosecutors I have ever seen, the DA of Boulder County. His name is Michael Daugherty. And we were so enamored with him, we have named him DA Daddy. He is kind, he's gentle. He is an amazing trial lawyer. His opening was one of the best I've ever seen. And I really didn't know a lot about him until I went to look him up while we were watching the trial. And it turns out that he's from New York. He went to Nassau Community College, Cornell, did his law school at BU, and he worked at the Manhattan DA's office. So I just texted Mark Betterow because someone said, do you think he knows Mark Betterow? And I said, hey, do you know a guy named Michael Daugherty from the Manhattan DA's office? He was there from 97 to 2010. And Mark Betterow said, I know Michael well. He is now the elected DA in Boulder. And I said, well, that's crazy because he's our new DA daddy. He said, I'm covering the mass shooting case in Boulder and he's trying it personally. And he is freaking amazing, the kindest and nicest, most gentleman and prosecutor you'd ever meet. He should have trained Adam Lally. And he said, he's a good guy. What can I say? We are trained differently in the Manhattan DA's office. So how about that for your Small World Story of the day? Mark Betterow knows our new DA daddy, Michael Daugherty. Isn't that crazy? And his opening was amazing. He really told a story, and it's only on WebEx, so we're not getting a very good view of him at all. But his words, his tone, his demeanor, it is everything that you want in a DA and then some and more. Law and Crime has Carly Gregg's hearing up. They had a hot mic moment before, which was pretty funny because you could hear everything that was going on in the courtroom. They were talking about all kinds of different things. So I told Mark, maybe you should come on one day and tell us about Michael Daugherty. And maybe now that we have the connect, right, into Michael Daugherty, maybe we could get Mark Betterow to do like a little intro. And then after this trial's over, maybe we could get Michael Daugherty on the show to talk about his experience and the case. Isn't that crazy? WebEx is just like another form of Zoom that you can do big meetings on. I don't know how many people you can have on Zoom at the same time, but WebEx is used in big corporations and courtrooms. And I don't know if it's more secure or you can just have more people on, but WebEx is something that's used in a lot of corporate type situations. So it is similar to Zoom. And it's got like weird, camera angles. The video's not great. It was better today though, didn't you think? What we were watching? We have Judge Daddy and DA Daddy and Crash Daddy. Judge Dewey K. Arthur, if you guys are new to this case, to the Carly Gregg case in Mississippi, we really like him too. For those of you who are unfamiliar with the Carly Gregg case, I'll give you a quick recap or a little summary. If I can, now that I'm covering so many cases at once, which I'm not used to doing, I go single thread a lot, getting them mixed up. Carly Gregg was 14 years old on March 19th of 2024. That's right. It was this year, only 6 months ago, that she murdered her mother. Hear them? They're hot micing it all over the place. She murdered her mother, Ashley Smiley, who was 40 years old and a math teacher at the high school that Carly attended, which was a public high school, Northwest Rankin High School in Mississippi. It's in Rankin County. After she murdered her mother, She used her mother's phone to text her stepfather, Heath Smiley, to ask when he was coming home, and then she lay in wait to kill him. But in between that, she called her friend and had her friend come over because she wanted to show her friend her mother's dead body. It's a horrific story. Carly was 14 at the time. They've been dressing her in what looks like Catholic school uniforms to come to court, so she looks very young and innocent. I saw some photos. I think it was Annie Elise who did a great piece on her, I think. Can't remember what show I was watching now, but they showed some older photos of her with braces. Did you guys see those photos? And she looks totally different, Carly Gregg. The stepfather survived. He was shot in the neck or shoulder. There's conflicting reports. We watched some pretrial hearings on this. We did a whole pretrial show and caught up on a lot of the pretrial shenanigans. Okay, that camera is going to make me nauseous. We need to take it down for a moment. The stepfather has survived, and he is requesting that she be released. So it's a wacky case. She's being tried as an adult. She recently just turned down a plea deal of 40 years, and she seems very, very, very immature, but she is super smart. She's wicked smart. She skipped the 3rd grade, scored very high on the ACT when she was 13 years old. I think she got a 30 on the ACT, and I don't remember what the ACTs are out of, so I can't even tell you. He wants her to be released. In fact, we watched one hearing where the entire gallery was filled with family members, and it was a bail reduction hearing because the bail is something like $1 million. And the judge said, "Can I see a show of hands in the courtroom? How many of you are okay with reducing bail?" And they all raised their hands in the courtroom. It's crazy. He didn't reduce her bond, though. It's still at $1 million. So she's been held in solitary confinement for 23 hours a day since she was arrested March, I think it was the same day, March 19th, 2024. She's facing up to 2 life sentences. And it's crazy. She's been ruled competent to stand trial. That happened in August. And she appeared with her attorney just August 28th to reject that plea deal. And we have a lot of questions. We have a lot of questions about this. You know, was this child born evil? Is she severely mentally ill? Did she undergo some very severe trauma that caused her to snap? We don't know because we haven't been privy to what any of the psychiatric evaluations have said yet. So it's going to be the expert testimony in this trial that is going to be very, very, very interesting. This trial is scheduled to start, I believe jury selection is scheduled to start on the 16th of September, which is next week. The judge wants this case going ahead, come hell or high water, because he said in one of the hearings that we watched, he said, quite frankly, let me see if I wrote it down. Quite frankly, if she's mentally ill, she needs to be released. Didn't he say something like that? Oh, see, now I'm into my Karen Reed notes from 2020. So he said something like that, right? He said, if she's mentally ill, she needs to be released, or she needs to get out of here, or something like that. Like, he really wants to find the truth here. He's not just looking for a conviction. And he thinks that if this young lady is mentally ill, then she needs to be in a place that can treat her. And she doesn't need to be in solitary for 23 hours a day. But people have pointed out that it's much safer for her to be in solitary than to be in Gen Pop. Look at me learning all the prison terms. You did say that, right, Gamer Ducko? He said she needs to be free. That's what it was, Jeannie Marie. You guys are so collaborative with me. Thank you. The older I get, the worse my short-term memory is. Sometimes I just can't even think of the words. He did say that, right? Katie said jail isn't set up for psych treatment, so she should be at the stage hospital if she's insane. Thanks, Fun Size, for becoming a new member. Good morning, Miss Kitty. This is such a disturbing case. It's afternoon for us here. It's 2:26 on the East Coast. We had some confusion this morning. I had it scheduled for 9 a.m. And then that was a placeholder. Then Law and Crime moved it to 9 to 10. So we moved it. And then they moved it to 2:30. So what we did was we pivoted. We pivoted and we started covering or recapping and going over some of the case out of Boulder, the mass shooting out of Boulder, which is horrific. Boulder was my home for many years, so it's a very personal story to me, as you know. We're going to hear some motions in lemonade today, as the closed captions like to call them. We may hear a motion to transfer this to juvenile court, so it's going to remain to be seen whether or not this trial is actually going to start on the 16th. Very disturbing. I don't know which one you're talking about, Sunset Seeker, but all the ones we're covering right now are disturbing. What? Yuri, again? Yuri, you're coming in here again with 20 memberships? Thank you. You're incredibly kind and generous today because Yuri's math teacher also gifted 20 memberships on the last stream. Thank you. Thank you. I really appreciate that. And to all of you who were gifted, welcome, welcome. Georgia White, nope, not today. Annette, mom of two, Robin P, all you guys, welcome, welcome. I think you're going to like it here. You guys are my cupcakes. And the reason for that is, well, there's a pink sign over there. That was my daily reminder, or it's over here. It says, you can't make everyone happy. You are not a cupcake. And as the mother of 5, that has been my mantra for the entire time that I've been a mother, which has been decades. You can't make everyone happy. You're not a cupcake. I can't make everyone happy because I'm going to tell you my opinions. And you might not always like them, but I'm never going to sit here and just be a neutral channel because how boring would that be for you guys? You're here for the commentary, right? But so it's sort of morphed into you guys being my cupcakes because you make me happy and I make you happy. So to each other, we are cupcakes. And for those who don't like it here and leave the nasty comments, they are given a one-way boarding pass because we have that ability here. In fact, we even have an emoji for that. There's the boarding pass emoji. Members have access to all kinds of fun emojis that we use for all the different trials that we're covering. There's my CU buffs. We've got that. I mean, the Karen retrial really started this trend because we have a puffy jacket. We have the old what if any. We are outraged is a favorite. And so many of them can be used multi-purpose for so many of the trials that we're covering. And you guys are so kind and generous and sweet to each other and supportive of each other. And it's a really fun place to be. Very supportive. Right? Need commentators to not make it so boring, right? Even though there's nothing funny about the cases that we cover, usually, we have to inject a little bit of humor because for a lot of people, including myself, it's a defense mechanism that when you're uncomfortable, sometimes you make jokes. So we try and do them in a sensitive way, but you guys keep me laughing. This chat is the funniest chat. No, but we do need a little moccasins emoji. Listen. That guy was like happy to be on camera. Did you see that? Hold on. I got to take that back a second. He walked in. He's like, what? I'm on camera. Oh, Nathan Wade vibes. And then he's like, what? Oh, he smiled. That was so cute. Let me know if you want me to cover this because this is crazy. If you didn't hear about this, I get most of my news from the New York Post because the New York Post covers things in a way that no other publication can. There is a senator out of California, a woman, who's chief of staff. She recently switched parties or something. Her chief of staff has filed a lawsuit against her for harassment, let's just say. Her chief of staff happens to be Gary Condit's son. Do you remember Gary Condit? You remember Chandra Levy? That whole thing? Levy, Chandra Levy. Now I have to say Levy because Josh Levy is Levy. Chandra Levy. Gary Condit's son is suing this senator, this female senator, and he's claiming that she forced him. I'm going to try and say this as gently as I can from my virgin viewers' ears. He forced him to perform acts on her in her car that he claimed caused him to herniate 3 discs in his back and dislocate his hip. And he also claims, in addition to that, let's just say they never had forcible intercourse. So it was like the other thing that she forced him to do. And it caused him to herniate 3 discs in his back and dislocate his hip. And he was married and she was married. And the lawsuit, which I had to go register with Sacramento courts just so I could get a copy of this lawsuit. It is 39 pages of craziness. And Scott, I don't know what you're sending me, but I'm going to take a look. And so I thought that when when I read this story, that's right, Sarah. When I read this story, I kind of thought, I don't know, in my head, I had this vision of this guy filing this lawsuit. Like he was like a young intern maybe. And he was like this hot, 20-year-old guy that she was getting it done with and stuff. And then I'm also interested because, it's Gary Condit's son-in-law, because I remember him being kind of not a great guy / politician / husband / and name it, right? And so now I had to do a deep dive into who this guy is, this Condit, the son, because I'm thinking, oh, he must be some hot. I don't know why I had it in my brain that he was this really hot. And listen, I'm not saying that men are not also victims of harassment and, things like that. But I think that in the interest of showing you this, because Law and Crime's not ready yet anyway, I want to introduce to you the plaintiff in that lawsuit, Chad Condit, who apparently was also running for state assembly in District 22. He's the victim here, the plaintiff in this lawsuit. He is Gary Condit's son. He's a husband, father, grandfather, local businessman, U.S. Navy veteran, and former assistant to the governor. He was also the chief of staff of Maria Alvarado Gil, whom he is suing and said forced him into these, what should we call them? Indecent, dangerous liaisons, maybe, perhaps? Dangerous liaisons? Yeah, that's him. And that's him. And she was making him do it in the car, even on trips they went on and everything. There must be more to this story. Yep. I wouldn't lie to you guys. I mean, I've got the receipts, I've got the lawsuit, and I feel like this is going to be, his name's Chad. Yeah, Chad Condit. What does she look like? Oh, you know what? Did I even pull a picture of her? Not sure if I did. Oh, here she is. Here they are together. And here's a post that he wrote about her. I want to thank everyone that supported our campaign for state assembly. We had a great team and great supporters. While this election did not go our way, we will continue to work to make a positive difference in our community. Thanks, Chad. And there she is, Maria Alvarado Gil. And then he even wrote this thing Maria Alvarado Gil is someone we can trust to stand up for us in the state Senate. Whether you're a Democrat, Independent, or Republican, we are Americans first, and Marie knows this. Please all vote for her. And there she is. And now he's suing her. Now he's suing her for forcing him to do the dirty in the car and on the vacation. And he even says, as part of the lawsuit, like she wormed her way into their family and ruined it. I don't know if he's still married or anything, but I mean, listen, it's that hip that'll kill you, right? So I thought that might be a fun little thing for us to do, maybe for an hour one day. If there's interest in it, and if I can think of a way to, talk about it in a way that we can. I mean, how can we not? How can we not see salt? Oh, come on. There's so much scratch here. There's no way this won't be wild and in the file. Nobody's covered. Don't tell anybody about it because I want to do it first. But somebody else speaking in the doors. You're like, it's my turn to be on camera. Yo, get out of here. I've got it. I've got the receipt. So don't tell anybody. All right. You're interested. You're into it, right? Okay, cool. Cool. Maybe I'll do that later, like as a quick hour because I have time today. Because now that I dropped my twins off at college, I've only got like one left to drive around who has things to do today. So there's that. Oh, eating pie. Okay, good. Yeah, if you guys can think of like some code words that we can use, that's good. They say in the lawsuit that she forced him to kiss it. Like it's just hip check. Yeah. I mean, you guys help me because I think we have to. Yeah, a lawyer actually picked it up. She forced him. Uh-oh. Hope that's not a juror. No, it can't be because we're in pretrial hearings. Forget it. I'm conflating my cases again. Yeah, and just the fact that his last name is Condit. Like, dude, you could have been like maybe a John Doe in the lawsuit. And really, that's like a federal, usually they're federal, those sexual harassment cases, but filed it in state court in Sacramento, California. And this, like, I don't know if I didn't do enough deep dive into it to know if she's running for reelection. Interesting timing, though, that he's filed it right before the election. Is he running for something? I have so many questions. She just switched over from the Democrat to the Republican Party. Not that I even want to get political about this because I just find the content of this lawsuit to be so humorous. Exactly. I don't even think he went to the hospital, Jeff. I mean, is this his way of like getting an easy divorce and showing his wife, like, look, honey, I'm filing this lawsuit because I really didn't want to do it. She forced me to do it. And men are victims too. I'm not making light of that, but you have to admit that there is somewhere in this lawsuit some humor. You want the deets, Kim? It's insane. What they done before she changed parties? I think so. I'm trying to wait. I'm not sure. Oh, but then she fired him. That's what it was. So she fired him. That's why he's mad. Because he swears that's why she fired him because he told her, look, I need to have back surgery. I can't do this anymore. And besides, what you're doing is nothing that I wanted in the first place. PMA, did he say no or tell her to stop asking for a friend? I'm not sure. I should be fine. I don't think there's a video. Well, this is Melissa. This is funny because they don't say going downtown, but they leave out the second half of that second word. And that's actually like in the lawsuit. And in fact, I tried to find some news coverage out of it. And the newscasters were like, the details of this lawsuit are so graphic that we can't even bring them to you. I'm like, oh, yes, we can. Don't you guys know how to mark things up on your laptops? Don't you know how to just like block out letters on the word? Because court is starting. It's up right now. Don't worry. We're just diverting a little bit. It's supposed to start at 2:30. So they're running a little bit late. We've seen a hot mic. We've seen people coming in and out of the courtroom. But this Judge Dewey Arthur did have a full calendar this morning, so he wanted to probably get rid of all the other hearings that he had so that the cameras could come in for this one because the other ones he had this morning are not going to be televised. She did. She had oh, this is it, Team Brittany. Team Brittany for the win. Don McLean is gonna be upset if we use American Pie, but how can we not use American Pie when she's a state senator? Like, that's it. Team Brittany, American Pie. You know how much I love you. Well, say it again. I love you, sis. The best. The best. Bring in the tea. Eating cookies, that's a good one too. I like it. I like it. I don't know. Yeah. Do you think maybe he got caught, so he sued her instead of admit it? Or maybe he got fired and he's mad and it's like retaliation. Yeah. They were playing Twister in the car. Yep. And I couldn't help but think of Robert Tellys and his backseat meetings. But in that case, it was consensual, right? Because Robert Tellys, Robert, was her name Roberta? Yeah, Roberta Lee Kennett. She never came out and said I didn't want to be there. He was forcing me. That was car yoga. Max Bang for the second wind. Second wind. Second wind. Car yoga. It is crazy. He is. He's Gary Condit's son. You heard it here first, folks. You heard it here first. And this is fantastic because we're clean here, right? We have a reputation as being clean here and just not using the words. So Linda, you could be onto something with Pet the Kitty. I like that. Danielle, you have to rewind. Gary Condit's son, who was the chief of staff for a California state senator, has sued her in a Sacramento, California court for harassment and forcing him to do things in a car that caused him to have herniated discs and dislocated hip. And then he got fired. He's mad. And the details are graphic, but I don't know if he's still married. That's what I wonder. I wonder. Oh my goodness. You guys are funny. I don't even know if they were in the back seat. They could have been in the front seat for all I know. I mean, but like the depositions that are going to take place in this case, first of all, the plaintiff is always deposed first. So he's going to have to give testimony first. Does he just think that the California State Senate and this senator that they're just going to settle with him real fast? Because I don't think she's like P. Diddy rich or anything. Remember how P. Diddy shut Cassie up real quick once she filed a lawsuit with something like 40 mil, 60 mil. So the senator's name is Maria Alvarado Gill, and the son of Gary Condit, his name is Chad Condit, also sued in that lawsuit. The California State Senate and Doe's 1 through 50 for all the people that enabled her to harass him and force him into such an indecent proposal. Smart car, I don't know. Did he ask his wife if it was okay to try other flavors? Yeah, I mean, they mentioned throuple throughout the lawsuit at some point, more than once. Estrella says he just got caught cheating by his wife, I bet. Also, it says California election mudslinging is out of pocket. Like, since I started voting, first election was for Gray Davis recall. OMFG. Yeah, that's another way. Filibuster. It's a filibuster. That's good. I like that. I made that up myself. I didn't see that anywhere. He's the real weed whacker. Very good, Iceman. Very good. No self-respect. Why would you want this out there publicly? I mean, why, right? We've talked about this before. Why do people file civil lawsuits? Money and revenge. In this case, maybe it's both. She grabbed me by the ears. Is that part of the lawsuit? You know what, Athena? I would not even. Heather, was she wearing an orange shirt and bamboo while forcing him? It's too funny. See, we needed that. We needed some comedic relief. And this chat is so hilarious. And that's why Donnie, not Wahlberg, we love it here because you've got the name. You fit right in. And here's we'll have a little trivia. When I was talking to Mark Betterow, when we were talking about DA Daddy and the fact that he knows him, I said, it's a small world, but I wouldn't want to paint it. Who remembers that comedian? Whose line was that? It's going to date me, I know, but whose line was that? Small world, but I wouldn't want to paint it. Anybody know? I know, Gina, I'm crying too. See, we needed this. We desperately needed a laugh because once we get into Carly Gregg, there's going to be no more laughing. I mean, dear Mark chuckle at this guy. Oh, I didn't even talk to him about that. I was talking to Mark about the Boulder case that we're covering, the mass shooting. That's a horrific case out of Boulder because the DA there, who we have come to call DA Daddy, his name is Michael Darty, also worked at when we looked him up, he worked at the Manhattan DA's office, and Mark Betterow happens to know him. So those are two different. We're having so many conversations at the same time. I don't think it was George Carlin. The one I'm thinking of is different. I thought it was, see if anybody gets it. No, Robin Williams, Emo Phillips. I thought it was Stephen Wright. Yes, Jeannie got it. Jeannie Marie got it. It was Stephen Wright, right? He had that very deadpan humor, like it's a small world. I wouldn't want to paint it. That's who I was thinking it was. But I've been wrong. Stephen Wright and his squirrely hair. Thank you. We're all dating ourselves, but it was very funny. Is he still alive? Yeah, you guys got it. Shopping downtown. That's it, spirit healing. He was shopping downtown. The senator forced him to go shopping downtown. Oh my gosh. At a store called American Pie. And it caused him to dislocate his hip and have 2 herniated discs. And even after he told her he was going to have back surgery, she wouldn't stop forcing him to go shopping downtown. I mean, it's a crazy lawsuit. I think we may need to do that later just for some comic relief. Let's see, do I have the sound on here? Not yet. Do they have the sound on here? For those of you who are just joining for this trial, welcome to the courtroom of Dewey K. Arthur in Rankin County, Mississippi, where the death penalty is in effect, but it's because Carly Gregg is not over the age of 18. It is unconstitutional to sentence a minor to the death penalty, so she is not eligible. Mr. Conde, can you describe how the injury occurred? But Your Honor, she got them. Now my neck has a crick in it. He is alive, Stephen Wright? Well, why is he not performing? Or is he? Oh, yes, maybe you're right. Maybe I should get Glare to do this one with me. Maybe I should. He's always good for a spontaneous live. I mean, I don't think he plans his lives ever. You could just be like, dude, come on with me. Like, and it could be, you know what? Don't tell him about it because it could be like a real reaction for him. Okay, here she comes. She's not dressed in the Shining outfit today. She's dressed in an actual dress. She looks much older. Their sound is not up yet. Wow, what a difference, right? What a difference from the Stephen King costume from hell that they were putting her in before. She looks older. The page boy haircut. I'm so conflicted about this case. Like I don't know what to think about it. All right, you guys turn up your sound. Not you guys. Court.
Madison Gregg, call number 2024-34169. We're here by way of pre-trial conference. All right. We'll begin with docket number 168. State filed a motion limiting to exclude motion of punishment. The defendant filed no response. Granted. Give me an order to that effect.
Yes, sir, Your Honor. One question regarding that punishment as well. The attempted murder statute requires bifurcation for guilt and sentencing. And of course, we would ask that any comments about sentencing be reserved for that, for the murder and the attempted
For
murder.
the sentencing things, yes.
Yes, sir.
Okay, so bifurcation means that there are two trials. The first trial is on guilt or innocence, right? The second trial would be the penalty phase, and that's what they mean by bifurcated. So when the defense does not respond to a motion, it's automatically granted. They wanted to prevent the defense here from mentioning any punishment or possible punishment. They did not oppose it, so that's automatically granted.
All right, docket number 169, motion in limine to exclude golden rule and jury nullification arguments. No response was filed. It's granted. State's getting in order. All right, motion docket number 170, motion in limine regarding facts not in evidence. No response was filed. Granted. Give me an order. Document number 171, motion in limine regarding speaking objections. No response was filed. Motion is granted.
Speaking objections, they're calling it motions in lemony, LEMONY, not lemonade.
Number 166, motion to suppress urine test. Heard from the state. I read the state's motion. Excuse me, I read the defense's motion. I read the state's response. State's burden of proof. Do you have any witnesses you wish to call?
I'm sorry, Your Honor.
It is the state's burden of proof. Does the state have any witnesses it wishes to call?
Sure, Your Honor. The state calls Corey Gerber.
All right.
This is a motion to suppress her urine test from when she was taken into custody or into the hospital or to the psych ward. They did a urine test and they want to, defense wants to suppress the results of that test. Judge said burden of proof is on the prosecution. You're calling witnesses. So these are the witnesses for the motion to suppress the urine test.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
You understand you're not allowed to answer this one answers up to other.
I do.
You may proceed.
If you would introduce yourself for the record.
My name is Corey Gerber.
And Mr. Gerber, what is your role currently?
I currently serve as the Rankin County Youth Court Prosecutor.
As a youth court prosecutor, do you have experience and information regarding what happens when an inmate is intaked at the juvenile detention facility?
I do.
And is there a policy and procedure put in place regarding drug screening of all offenders once they're taken into custody?
It is the practice of the Juvenile Detention Center to drug test everybody that is brought in. That is my understanding.
And to be clear, could you explain for me kind of the breakdown out at the juvenile detention center? There is the youth part, the court part, of which you're a prosecutor, and then there is the detention part. Is that correct?
They're two separate entities. The Juvenile Detention Center is run by the sheriff. The Rankin County Youth Court is the court, and they are separated by locked doors. We are two separate entities. Yes.
Hold on just a second. Let me check. It's all right.
Testing.
Mr. Gerber, you said that each inmate is drug screened at admission. Could you tell the court what's the purpose of those drug screens?
My understanding is that every child detainee that is brought to the Juvenile Detention Center is drug tested for the purposes of safety. There are multiple things that are done when a child is brought in. One, they are to meet with a mental health crisis assessor. The other is they are drug tested. And my understanding is that they are drug tested just to make sure that whatever substances are in their body for purposes of medical care.
And are you familiar with the drug screening that's done in conjunction with that?
I am.
Could you tell the court about that?
So those are observed screens. Those screens are taken. Once the screen is done, they are presented to the lab. Then the lab would run those tests. The lab is on site. That is a very expensive piece of machinery. I am not an expert in how that machine is run. I can tell you that that machine is calibrated once a week. Every time that the machine is started before any tests are run, there are controls that have to pass. You have 3 attempts to pass those controls. If the controls do not pass at that time, the machine has to be recalibrated until the controls do pass. Otherwise, we do not run the tests.
And Mr. Gerber, do you have any personal knowledge about whether or not that machine was running appropriately on March the 20th of 2024?
I do not have any personal knowledge other than if it wasn't running appropriately, it would not have been running.
So they would not have performed a test if it was not working appropriately?
They would not have ran the test if it was not working appropriately.
You talked about that there's some checks and balances in place and calibration to make sure that the machine is running correctly. How reliable are the results from these particular drug screens?
They're very reliable. If they weren't reliable, we wouldn't use them. We wouldn't waste anybody's time or money doing the tests. I will say they are not confirmed tests. So typically what you have is whenever a urine test is had and you get a result, if that result is a positive test, what would typically happen in a case like that is that urine would be sent off for confirmation. We do not do that. We use that test primarily for assessment, not for any evidentiary value. We are not presenting that information to the court without some other types of discussion.
And so the screening's done for safety. The screening has some checks and balances in place. And you said that the results are very reliable. So if someone had presumed tested positive during one of those screens, like the defendant did in this case, that would be very reliable.
It would be reliable. If there was any question, typically what we would do is send that person for a separate test. Depending on what you're testing for is going to be the question. There are some things that we test for that are not as reliable as others. An example would be methamphetamines. Those are the ones that we typically have the question on. We do send those. We don't send that urine for confirmation. Instead, what we do is send the person out to give another sample and have that sent for confirmation.
Court's indulgence.
Court's indulgence. They're very polite in Mississippi. I had to make sure it was on normal speed
With regards to the test performed by
because it sounds to me like they're speaking really fast. I thought I speak fast. This is normal speed.
Gregg, has anyone provided you anything to show that that particular test was not reliable?
I don't recall seeing that test, nor has anyone mentioned that it wouldn't be reliable.
No further question.
Thank you, Your Honor. Now, Corey, okay, why was Carly at the youth detention center to begin with?
Under federal statute, a child cannot be detained in an adult facility without an interest of justice hearing being had within 6 hours of that child being detained. So as a courtesy to the judge, Carly would have been at the juvenile detention center until a hearing could be scheduled for purposes of that interest of justice. She was there long enough for that hearing to be scheduled. She was transported from the juvenile detention center to the jail here or to the court. I'm not sure where she was sent after that, but that hearing was scheduled.
Okay, so, because court, according to the statute, she's considered an adult, correct?
Yes.
Okay. And so, my understanding, why is it that everybody is tested in the youth detention center? Isn't there some federal grant that y'all are under that requires that?
I'm not certain whether there's a federal grant that requires everybody to be tested or not. Again, my understanding is they are tested out there for purposes of safety issues, safety reasons.
Okay, so she was only going to be held there for a few hours until she could be brought over here to Rankin County.
As soon as the hearing could be scheduled, correct.
Okay, and so there wasn't a warrant or anything like that to have her do this test, correct?
Not that I'm aware of.
And there was no probable cause where somebody was saying that we want this test done, correct?
I'm not certain. The only thing I can say is that she was tested for the same reasons that anybody else that would be brought to that detention center was tested for.
Okay. But she was an adult and everyone else would have been children, correct? Or youth? Okay, correct.
She would be
treated.
classified as an adult. She's still a child.
Yes, I agree with you. She's still a child, but she would have been classified as adult.
Yes.
Okay. And so now when you were talking about the test itself, and you said that it's calibrated once a week. Okay. Is there like a logbook that you have that says that it's calibrated?
I don't calibrate it. I just know that the protocol of practice is that it is calibrated once a week, and that's going to be the first start, typically on Monday.
So you don't know if these things are even kept. Is that correct?
Oh, I don't know. I don't. I'm not the person running the machine.
Okay.
Yeah, I was wondering why he was testifying about calibration if he really has no knowledge of whether it was calibrated. Similar to when you do a breathalyzer, or when you're stopped by a traffic stop using a radar gun. They have to show in court that that was properly calibrated. So I don't think that he's the witness to do that.
And the night that this happened, who ran the machine?
I have no idea.
Okay. And if I showed you the test card, would you be able to tell us who ran the machine?
Yes.
Okay. Yeah, approach the witness, John.
Yes, show the counsel officer.
Thanks, Kiki.
Then we're gonna show the witnesses.
No objection, Your Honor.
Good point, though, right?
One for identification.
She was being classified as an adult. Why were you treating her like a juvenile?
That's the test card that we have. In fact, that's the only document that we have concerning this test.
This is the only document. There's no there's no back sheet to this.
That is the only document that we've been presented.
Then no, I can't tell you you ran the test.
Okay.
Oh, interesting.
From looking at that document, can you even say that it's calibrated or it's been checked or anything?
I can't. Not from looking at this document, no.
Okay. Now, I guess, once these samples, these samples are given, and you said they're taken to the lab, and the machine's in the lab, is that correct?
That's correct.
And then they're run at that, the samples run at that point.
It is run once the machine is started. So, a better answer for your question, is that if the sample is taken at night, then it's placed in the lab would be started by the person that runs the machine when they would get there the next morning, and then it would be ran in. So, I don't know what time this was taken. I can tell you the date that it was taken based on this. It was collected on the 20th, according to this sheet. And it would have been ran the same day at 9:21.
Okay. And when these samples are, I guess, run, what happens, I guess, is there going to be extra fluid? Or is it marked and then it's put in I guess you'll have a refrigerator or something?
So yes, that when you have a refrigerator, but no, the extra fluid is disposed of. We do not keep the urine, not to my knowledge.
Okay, so you run this test. So let's get back to this, where you say you use the test for, because the test is for the youth court, basically. Is that correct?
Well, it depends on the case. I mean, yes. I mean, if this child were to be a child under the jurisdiction of the youth court, this test could be used for multiple things. One, to give the detention staff an idea of what is in that child's system for purposes of maintaining the child at the juvenile detention center. The second could be for purposes of disposition. The youth court is a court of rehabilitation. We want to address the whole child. So if I see this particular test, I can tell you that it's positive for cannabinoids in an amount of 237.7 nanograms per milliliter with a cutoff of being 20. That would indicate that this child has consumed some type of cannabinoids. We would want to know that moving forward for purposes of A&D assessments and possibly enrolling them in some type of program to address cannabinoid use. If there is a question as to whether or not this is accurate, what would happen at that point is we would send that child for something else. But these tests are are reliable, they're just not confirmed. So there is
Right.
no, I would not use this as an evidentiary test.
Right, and that's what I'm getting at, is an evidentiary test to say that is actually what it is. That's not what you use them for, and that's not what they're designed to be used for, correct?
That's not what I use it for. Again, this is just an assessment tool used by the court for purposes of disposition. In the event that there's no contest between the child or the person, the donor, sometimes adults get these tests. If there's no contest about what is found in these tests, at that point they can be submitted to the court. But I do not submit these to the court for evidentiary value and adjudication.
So why should they use them
Where we're
now?
at right now is, you said they're calibrated. There's no calibration documents or anything that I provided you or that you have in front of you, correct?
I don't have it, no. If you haven't provided it.
And I think the only thing I gave you is a test card that was given to us.
That's correct.
Okay. And so that doesn't tell who did the test. It doesn't say if the other safeguards have been done on the test. It doesn't, is the person even qualified who ran the test? We don't even know that, do we?
I will tell you that there are only certain people that are allowed to touch that very expensive machine. They are all qualified to run it. But I can't tell you who did that particular day. As to your other question, it was collected by someone in the Rankin County Sheriff's Department. So that would be a detention staff, but I do not know who that would have been. That information can be gathered, but I don't have it.
No further questions, Chairman.
Can I read the exhibit with my court reporter?
Yes. I'm trying to steal your exhibits.
Read away.
Raise your arm. Mr. Gerber, as I understood it on cross-examination, you said these tests are for, again, safety and medical purposes for the detention staff as well as the donor?
As well as disposition. In the adult world, that would be sentencing. We want to make sure that we have all the information available to us to make sure that the rehabilitation process, it happens. So they have multiple uses, yes.
When the detention center finds someone is tested positive for a substance like Ms. Gregg did in this case, why is that important for them to know from a safety standpoint?
Well, for example, if it had been fentanyl, we would have taken the child directly to the hospital. The other is we want to make sure that there's no interaction with anything else that's going on. I don't work in the detention center. I don't want to speak for them, but I mean, I think it's fairly obvious that we want to know if the child is under the influence of any type of drug while they're in the detention center.
And if the child admits that they've used drugs, would that tend to corroborate the test results as well?
Yes.
Do you have any information that Ms. Gregg did not corroborate this test? Did you sit here today?
No, I don't have any information.
No further questions, Your Honor.
Stand down. State may call its next witness.
No further questions.
Stand down.
Defense have any witnesses that wishes to call on this issue?
No, Your Honor.
All right, argument by the state.
Now they argue. I like this judge.
From here is voting, Your Honor. The state outlined in our response and then filed an amended response. I want to bring that to the court's attention. Initially, we believed that the Juvenile Detention Center was under a particular grant through the OJJDP, which is the Office of Juvenile Justice and Delinquency Prevention. That federal grant does require drug testing. Upon communications with the Board of Supervisors, it's actually a different grant than we initially cited in our response. So I did file an amended response attaching the appropriate grant that does in fact require drug screens of all offenders at entry. Or that does require, drug screens, as well as the Rankin County Sheriff Department's Juvenile Detention Center Policies and Procedures 2.2F Those were provided to me by the Sheriff's Department, which again outlined that each offender is screened there at the detention center immediately. It also outlines the policies and procedures that are to take place upon entry. These screens, as you heard from Mr. Gerber, are very reliable. The state is not attempting to use this screen for quantification, rather for presumption. As pointed out in our response, the defendant has admitted during particular evaluations and through other witnesses that she did in fact use marijuana. She has said that she used it during her assessment with Region 8 as well. She says that she smoked it. This happened on the 19th. She says that she smoked it on the 18th at least. We believe that this information is certainly pertinent since she has asserted her right to claim an insanity defense. As this court's well aware, in cases such as Crawford v. State, once the defendant puts their sanity at issue, the door is thrown wide open for the admission of evidence of every act of the accused's life relevant to the issue of insanity or sanity and is admissible in evidence. That's Crawford v. State, 867 Southern 2nd, 196. Additionally, Mississippi Rules of Evidence 703 state that an expert can rely on facts and data that are not necessarily admissible in evidence. And so our doctor, Dr. Pickett, has relied upon Carly's admissions of using marijuana as well as this presumptive test to show that is and does call into question her mental state. As this court is also aware, voluntary intoxication is not a defense to murder. It does not entitle you to an insanity defense. And so we believe that 703 as well as Crawford and the admissions by the defendant make this test even more reliable.
What if it was synthetic marijuana? Do you know that case about the woman in California who killed her boyfriend or some guy she met on Tinder, like stabbed him like 100 times, and she claimed marijuana induced psychosis and she got off? Reefer Madness, anyone? I just thought of that. What if it was like synthetic marijuana? That can make people really psychotic, I've heard. Worked for that woman in California.
Isn't just a piece of paper that shows that she had marijuana in her system. We have the defendant herself saying that she'd smoked marijuana at or around the time of the crime, as well as additional witnesses that we intend to introduce. As outlined in our arguments, we also believe that this urine screen is akin to the DNA buccal swab found in Maryland v. King. There was a 3-part test. We believe that it's similar in that the Rankin County Detention Center's booking policies require that all offenders be screened, that urine sample is the least and minimally invasive drug screen that's available to them at the time. And as such, we believe that the drug screen itself should be admissible under Maryland v. King. Also as cited in our arguments, and what Mr. Gerber talked about today was that these tests are done for the safety of both the offender as well as the facility. And we believe that that record is actually a part of Carly Gregg's medical records. And because of that, and because of her claim of insanity, she has waived all medical privilege with regards to anything that might have to do with her mental state at the time of the crime. Specifically, we cite to Rule 503F of the Mississippi Rules of Evidence, as well as the cases outlined in our response. We ask that the state be allowed, that our evaluating psychiatrists be allowed to review and talk about the results from this urine screen as they do affect the defendant's mental state at the time of the crime. And then additionally, we would argue that if a search warrant was required, Holloman v. State would apply. In this case, it was a drunk driver who killed someone driving in a car. Law enforcement was on the scene. They observed the presence of beer cans, empty syringes, and bottle containing unidentified liquids. At the time, the person's blood was drawn, and also a urine sample was taken. There was the presence of methamphetamines and cocaine. This sample was taken without a warrant, similar to what we have here, and the court found that a warrantless search is permissible in certain exigent circumstances if it can be shown that grounds existed to conduct the search that, had time permitted, would reasonably have satisfied a disinterested magistrate that a warrant should be properly issued. And similar to Holloman in this case, the substances that were in Ms. Gregg's system at the time can dissipate over a period of time. And this screen was done on the 20th. She was brought over hours later. And we would argue, Your Honor, that if a warrant was got, if we had received a warrant, had to serve it on her and get an additional sample, that would be even more far removed than this sample was on the 20th rather than the 19th at the time of the crime. We would, of course, also state that, as pointed out, it's going to come into evidence that Ms. Gregg was using marijuana. And we believe that if it doesn't fall under the warrantless search and for the safety and within her medical records and the alternative, the state would argue that this would fall in the inevitable discovery doctrine. And admittedly, under that doctrine, you have to show that law enforcement, there was some misconduct, and that but for the misconduct, these items would have come forward. There's been no such misconduct in this case. However, there is a test that outlines when things would come into play if it was inevitably discovered. And we believe that's the same thing with a shearing screen. Based on admissions by the defendant as well as other evidence, law enforcement had at the time in their possession illegal substances, the presence of the vape pens that they had seized from the house, and knew of
The vape pens. Somebody, sorry, I unhighlighted it too quickly, but yes, the mother found, right, the mom, Ashley Smiley, found something, Melissa said, in her room, in Carly's room, right before Carly went into her mother's bedroom to get the gun to shoot her. Is that what she found? Now they're talking about vape pens that were found. Maybe that's what the mother found, which caused Carly to snap and kill her.
the fact that there may be a potential for drugs to be in her system. We would certainly ask, Your Honor, to consider all of those exceptions and rule that the urine screen would be admissible for its purpose of showing that marijuana was in fact in her system and not for a quantitative state.
That's right. If it was in a pen, you don't, who knows what was in it? It wasn't a joint. Old-fashioned plant in it.
First of all, Your Honor, I'm just going to briefly touch base. The state brought up the fact of basically the indigent circumstance where you can draw blood. The Supreme Court of the United States changed that in McNeely, Missouri versus McNeely in 2013. You now have to have a warrant. So when the state's saying that you do not have to have a warrant in that type, like in the hallway situation, that was a different time. That was okay at that time. That would have been under the Shoemaker ruling that said that there were exigent circumstances and that you could get away with not having a warrant. That has now changed. The one thing I want to say is that with this charge, Carly was charged as an adult and she was taken to the youth detention center, and it puts her in a different status than most people that are going to the youth detention center. Most of the people that are going to the youth detention center are being handled as youth. In fact, I would say all of them except a very small, minute amount.
Wait, Mississippi friends, is weed legal in Mississippi? My guess would be that it's not, but you tell me. Can you get a marijuana, filled vape pen in Mississippi at a legal store? Or are these kids buying them off the black market and God knows what's in them? I'm curious. And in any event, if you're 14, you may get something that's off market anyway, but I'm curious about that.
Carly's situation, she's entitled to due process, which is there has to be a warrant, there has to be probable cause, there has to be some of the protections built in. They bring up the Maryland v. King case, and they say, well, in Maryland v. King, there was actually a state statute that mandated certain testing.
Makes sense.
And the Supreme Court was looking to see if that was viable, if that was a viable law. And they came back and they said, yes, if there was a it validated the law. It said that there was a judicial reason for them to have the law, to have the testing. So therefore, what they did in Maryland versus King was okay. That's not the type of situation that we have here. There is no Mississippi law. There is no federal law that says that this shall be done. This is just the policy and procedure of the Rankin County Detention Center. And so what's happened is she's entitled to due process, and that didn't happen in this situation. There is no probable cause, there is no warrant. That was testified from the stand. The next thing that I want to bring up and put to the attention of the court, in order for a test to be valid, you have to have the person, and this is under Mississippi law, and this is any of these chemical tests, you have to know who the person is performing the test. You have to know the testing procedures. It has to be laid out somehow, and it has to be presented to the court and say, hey, this is done. And then the last thing is there has to be something to show that it's reliable. The way they show that it's reliable is having calibration records. You have the information of who did the test, how it was done, when it was done, and it was done according to the way the test was supposed to be carried out. We don't have any of that. The only thing that has been presented to us is a one-page paper, and on the bottom of the paper, it's document 1 of 1. It's not 1 of 10 or something like. There's a whole bunch of other documents that go with it. You have a test card. The other thing that comes into play is the state is wanting. They say, well, first of all, the test is not designed to be a standalone test. It is not to say what you're seeing in that test is what's in her system. It's only an identification test. They use it for that purpose. They do not use it for evidentiary purposes. What the state's wanting to do is take that test and then turn it into evidentiary purposes. They say, well, we just want to have it as like an identification kind of thing. Well, no, they're wanting to, in their reports, they're going in and trying to say whether or not she's under the influence at the time based upon that test.
Okay, compare this with the Karen Reed trial. Same concept. Remember how the lab technician came in from the hospital where they drew Karen's blood, which was secondary to her admission on a 72-hour hold or a section 12 or whatever they call it in Massachusetts now. I forgot, a section 12. That 2 people came in from the hospital to say that we are not in the business of providing legal results to be used in court. That's not what we're doing here. And yet they used them in court. And it seems to have confused the jury. And that's what they're trying to prevent here. Because these tests are not supposed to be used in court. And that witness, in my opinion, did not make a strong enough case because he even admitted himself that he was not even the right witness to testify to this. He doesn't work in the juvenile facility. He works in the juvenile court system. And these tests are not to be used in court. So this is what should have happened in the Karen Reed case. But, Judge Cannoni.
Which is an invalid test. It does not show, it doesn't meet any of the requirements of being a valid test by how it was done, who did it, was it calibrated, did they follow the protocols? None of that stuff. None of it has been provided to us. And also, there's been no consent. There's been no testimony that there's no consent. There's no warrant. The test wasn't done right. It's being used for a different purpose than what the youth detention center uses it for. For all those reasons, Your Honor, we ask that the test be excluded at this time.
I think it's a good argument.
Thanks for making it reply.
Is there?
Synthetic marijuana is different, Mary. But I understand what you're trying to say. Synthetic
I
marijuana.
believe that Missouri versus McNeely deals with warrants for blood draws, and in this case, we're talking about a urine screen. Also, Mr. Camp mentioned the laws in Mississippi and the statutes about calibration, and I believe what he's referenced it to is the implied consent law, which talks about intoxilizers, not the drug urine screens. Again, we believe that this does fall within the exceptions as cited in our amended response and also argued today. And more importantly, we believe that it falls within Ms. Gregg's medical records upon which she's waived any privilege to, as well as under Rule 703, and that our expert should be allowed to rely upon the presence of marijuana in her system at or near the time of the crime, including the day after the offense, to render his opinions regarding her mental state at the time. We ask that the urine drug screen not be suppressed in its entirety, Your Honor.
Will he rule from the bench or will he take it under advisement? What say you? We're a little behind, so no spoilers.
This court looked at several different cases, in particular Skinner, Von Rath, Vernonia, Maryland versus King. In addition, the court also read Chandler versus Miller, and Ferguson versus City of Charleston. In this particular case, because the need for a warrant is greatly diminished here, where the arrestee was already in valid police custody for a serious offense, supported by probable cause, the search is analyzed by reference to reasonableness, not individualized suspicion. Reasonableness is determined by weighing the promotion of a legitimate governmental interest against the degree to which the search intrudes upon an individual's privacy. The court would find that the government has there's a legitimate governmental interest in determining whether or not somebody is under the influence in the juvenile detention center, not for the purposes of prosecution, but for the purposes of safety of the accused. Obviously, like Mr. Gerber testified, if somebody tested positive for fentanyl, there's serious withdrawal issues. Well documented. It's not hard to find that out there. I'm not sure the juvenile detention center is equipped to handle those type of situations. That's a valid governmental reason to do it. Looking at Skinner, Von Rath, and Vernonia, the court believes that falls into that. Additionally, the court looked at Jones versus State, Mississippi case cited 881 Southern 2nd 209. The physician-patient privilege was waived in this particular case. And in Jones, the evidence was actually used to prosecute the person. That was not the intent of this evidence. The intent of this evidence was to find out whether or not there was a critical medical need that needed to be assessed at that moment. Now, the court would have a different holding if the state was attempting to offer this to prove possession of cannabinoids or some other crime, but that's not what it's being offered for. In retrospect, the state was able to go back and look at that and raise it for the defendant's insanity defense. So for those reasons, in the case law cited, Maryland versus King, the court would also find that a urine analysis is the least invasive and most reliable method to obtain a drug screen. A needle would be very invasive. Buccal swabs are not considered to be very reliable. The saliva type testing. Hair testing is invasive. You're removing a piece of hair from the child's body. And in addition, the reliability of those in short periods of time are not where they need to be, so it shows too great of a window. So for those reasons, the court is going to deny the motion to suppress. However, the court is going to restrict the state. You're not to get into this in your case in chief. It can only be used if and when the defendant raises their insanity defense.
Okay.
The court's rule states to give me an order. All right. Next,
All right. Did you
was a
understand
motion
that?
for
So they can only use it if they raise an insanity defense. Cannot be brought up during their case in chief, the prosecution. They're not allowed to whip out that card and say, when she was brought into the juvenile detention center, she was urine tested and showed positive for marijuana. But, you know, I'm going to disagree with that a little bit. I mean, I think he split the baby there, and I hate that expression. Where did that even come from? Split the baby. I'm not even going to say that anymore. I think he just, went right down the middle with this decision, because you can't really use it as a shield and a sword, right? You can't say, okay, well, we're going to try her as an adult, but for an adult, you would need a warrant. But because she was brought to the juvenile detention center, that they automatically take urine as a matter of course with every person who comes in there. So even though you're going to be treated as an adult, we still didn't need a warrant and it was not invasive. But if and when they bring up their insanity defense, which they have said that they are going to, then the case, the state in their rebuttal case is allowed to bring in these urine results, which apparently showed positive for marijuana. I didn't get that it showed anything else. But then again, if she was smoking out of a vape pen, and I saw a lot of discussion about this in the chat, marijuana is not legal in Mississippi. It's medicinal, but is it medicinal in a vape pen? And if she was buying vape pens or getting a hold of vape pens, God knows what's in them. We pointed out that case in California where the woman took one hit out of a bong, like someone said, and it was synthetic, and she killed a guy, like stabbed him 100 times. She was on her first date, I think, with this guy from Tinder or something. Thanks, David. But the baby comes from the Bible. Thank you. I don't like that expression, but I don't know any other expression that, sort of says the same thing. So it could also work to the advantage of the defense, although, because I don't know if that urine test can discern some sort of synthetic marijuana from the actual plant, right? I don't know. So we'll see how that plays out. But he ruled from the bench. He had already thought about his decision, you could tell. And he's steering this train right down the track.
Order document number 177, the response was filed late. As such, it will not be considered.
Nope.
Motion for gag order is granted. Give me an order.
Motion for gag orders granted.
Next motion is document number 175, motion to enforce the court's previous orders and compel a motion limiting to exclude evidence not previously discovered, produced and discovered. Again, the response was filed late. Document number 174, motion limiting to exclude insanity defense, exclude testimony of Dr. Gerald Lebrun, Dr. Mark Webb, and Dr. Clark. Again, there was a late response filed. However, we're going to have to deal with the issue of late file discovery. So I want to hear it all at once. State's
Okay.
motion, I'll hear you out.
Well, there's a judge who's not putting up with anything of anything. Why were they filing all of their responses late? What's the excuse for that? There really isn't one. And that's a lot of times a judge will automatically deny your motion or grant your motion if the response is late. There are court rules and you have to abide by them. And I'm a rules person when it comes to court and procedure person. We'll see. But this is in the interest of justice. On behalf of this child being tried as an adult, they should be allowed to use the insanity defense despite their late exchange. Maybe they've got a good excuse for it. Let's listen up. The female attorney, let me get myself out of the way here, is not happy. She's stunning, by the way. The defense attorney, female.
Court's indulgence, I'm trying to get it together.
Once she's getting that together, for the record, even though the responses were filed late and the others, I did read them before I granted approval, before I granted selection. All right, you can see.
If anybody can help Toy with this. Toy says, I didn't understand what the prosecutor was saying about bottles and needles. Did she mean inside the house?
And I'll start with our motion to enforce the court's previous orders to compel a motion limited to exclude evidence not previously produced in discovery. This court entered an order directing both parties to exchange discovery that was in their possession at that time by August the 20th, 2024.
I think I actually worked on it 2-3 times before.
That's correct, Sharon. The last order regarding discovery said that all discovery within the party's possession, there was also an in-court hearing regarding that, was to be turned over or the possibility to be excluded.
All right, let's go.
So
Where are you trying to exclude? Which witnesses?
yes, sir, Your Honor. So as of August the 20th, 2024, the state had 0 witnesses from the defendant and or any substance of their testimony. So we filed this motion on August the 30th, asking that pretty much any evidence that they sought to introduce at that point be excluded because we have received none. So to be clear, the defendant had dropped off an external hard drive, a jump drive at our office. It contained photographs. It contained an investigative journal by someone by the name of Amber Floyd. It did not contain anyone's testimony, anyone's information, and we were not provided the substance of anyone's testimony. During that same meeting, this was plea negotiations. The state had offered and asked, and quite frankly begged, for the names of anyone who would provide any information regarding the defendant's potential mental state at the time. We were not provided that information. However, the defense attorneys told us during that meeting that they knew the names of several teachers, as well as had a statement that the victim, the living victim in this case, Heath Smiley, had prepared, where they had sent him questions and he responded to those questions in writing, as well as other witnesses. We asked that be turned over on that day. It was not. We've asked that it be turned over subsequent to that, and it was not until September the 3rd that the state received a list of witnesses from the defendant. And I apologize, Judge, may I get that?
You have a copy of it?
Yes, sir.
Of the list you received.
Yes, sir, Your Honor.
That's right, mistrial. The judge was very clear at the last hearing. He did not want anything coming in late.
On September the 3rd, the state was emailed a witness list that contained the name of Heath Smiley, stating that his proposed testimony would regard his personal knowledge and observation of the events on March the 19th, 2024, his relationship with Carly's mother, Carly's relationship with Heath, Ashley Smiley's mental and physical state, which we've been provided no documents to that effect, Carly's behavior and mental health issues from the fall of 2023 through the present. At this point, we still have not been provided any documentation, any statements, anything regarding any mental state other than the records that we've requested from 2023 outside of Mr. Smiley's interview with law enforcement on April the 4th that we provided.
Well, that's interesting. Heath Smiley, the stepfather, I guess I shouldn't be that surprised. He's gunning for her release, that she attempted to kill and he survived because she shot him in the neck or the shoulder, is a witness for the defense who wants to testify all about Carly's mental health history. I guess I shouldn't be surprised by it, but we don't see this very often.
Additionally, it says that he will talk about the investigation in this matter by the Sheriff's Department as well as the Rankin County District Attorney's Office. Essentially, Vicki Breland has pretty much the exact same substance of testimony. That is the deceased victim, Ashley Smiley's mother. Next witness is James Daniel Floyd. He is the brother-in-law of the deceased victim, Ashley Smiley. We have no substance of his testimony other than he will testify regarding his personal knowledge and observations regarding the events on March the 19th, 2024, and the investigation by the Rankin County Sheriff's Office. No information provided by him other than that, with the exception of contact information. BG, who the state has interviewed, and SR, who the state has interviewed. Next, they list a Shira Higbee. It is believed that Ms. Higbee is a teacher and that this is one of the individuals, again, that the defendant knew about far in advance of August the 20th, as well as Tricia Gilbreth. Again, it appears to be a teacher of Carly's that the defendant knew about far in advance of August the 20th. The next name, Dr. Andrew Clark, which he was not retained before August the 20th. So, of course, that was not in their possession at the time. We have a separate motion regarding Mr. Clark. And then Corey Garber, which we do not object, of course, to the testimony that he provided. But certainly, so we're asking that any testimony that Mr. Smiley is called to testify about outside of the two statements that he's provided to law enforcement in this case be excluded. We ask that any testimony by Vicki Breland regarding anything at all be excluded, that the testimony of James Daniel Floyd regarding any type of testimony be excluded, that BG, anything outside of the interviews that he's provided to our office be excluded, and those have been turned over to the defense, as well as SR. Same thing for her. Our office provided statements to them, recorded and typed up interview notes. And then we're asking that Shira Higbee, Tricia Gilbreth be excluded. And of course, we asked separately that Dr. Andrew Clark be excluded. But those were all people that were in the possession of the defendant prior to August the 20th, 24. In addition to,
Hang on before we leave that. Do you have a copy of the witness list?
yes, sir. May I approach?
Mark, yes.
And Your Honor, for the record, I'm going to show it to them. I have the email where it was sent September the 3rd at 4:15 to our office.
Her mother was apparently a beloved math teacher at the high school. She was 40 years old. And they just listed all of the witnesses from the family that want to testify on Carly's behalf. The grandmother, the brother-in-law, the stepfather who she tried to kill. I don't know anything about the bio dad. I don't know if anybody does know. Thank you, Bernadette.
We, of course, outlined our arguments within our motion as to why we believe that those witnesses should be excluded. I mean, first and foremost, the fact that they violated this court's multiple orders regarding discovery, that by their own admission, they had this information and for whatever reason chose to wait till September the 3rd to produce it. There's no good reason other than willful conduct for them to have done such. There were multiple conversations between the state and the defense about turning over this information. This is not new information. This is not something that wasn't in their possession. This is something that we certainly believe is akin to a willful attempt to hide evidence. We ask that each of those witnesses,
It's not willful.
with the exception of Mr. Smiley, and the testimony that he's previously provided to law enforcement, be excluded. Would the court like for me to proceed with regards to our other motion in limine for the experts?
No. Any further argument as to these witnesses?
No, sir.
Okay, the response.
Okay, so this is just with regard to late witness exchange, whether these witnesses should be allowed to testify, including most of their relatives. This attorney's name is Caleb Coleman, Coleman. Female defense attorney, her name is Bridget Todd. Max Bang is right. This case is sad and forcing us all to look at some really difficult issues in our society. I'm going to FF it a bit.
You know, we provided the state a witness list. I think it was sent over on the 3rd of September, if I remember, and I think that's when it was told to the court. I don't think the state is saying that they're surprised as far as any of the witnesses. I think what they're asking for is for the witnesses to be struck. I have brought some case law dealing with that issue for the court, if I may approach, Your Honor.
I'd like to see your case law.
Dealing with, when we're talking about witnesses being struck and everything, Your Honor, the issue of witnesses not being allowed to be used, it gets into the issue of surprise, whether or not the other side is being surprised. Most of the time, in all the case law, it is either in the middle of trial when that's taking place, or right on the eve of trial.
What about Page versus State?
Again, Your Honor, I'm not familiar with Page versus
Page
State.
versus State was 11 days before trial. The defendant provided a list of witnesses, but did not provide the substance of their testimony. He made the exact same argument that you've made before this court in regards to an affirmative defense of alibi. And the Supreme Court said the court was right to strike it down and exclude it.
Well, my understanding of following in looking at the case law as far as, I guess, what has been provided and everything, most of the witnesses that we have are witnesses that we have gotten from the state.
Okay, the Supreme Court's also dealt with that. There is no exception. Under the defendant's requirement to disclose witnesses in Davis versus State, 9.04C1 clearly required the defendant to disclose the names and addresses of all witnesses in chief, which the defendant may offer at trial, together with a copy of any written or recorded statement or oral statement they were aware of, and the substance of any oral statement. The rule contains no exception for a witness who is referenced in materials that the state produced and discovered. So I will start here. Show this your burden of proof. Show me what you produced as to Heath Smiley.
Yeah. I'm having secondhand discomfort and embarrassment for this attorney right now, being put on the spot. It's like being back in law school, year one.
We don't have any written statements from Heath Smiley.
Did he give you any oral statements?
Just what the same thing that he's given to both sides. I mean, that's the.
Great. So all he'll be able to testify to is what was provided in the state's discovery, correct?
That's correct, Your Honor.
Okay, so he'll not be testifying to anything other than what he's testified to in open court or what he's given a statement on.
That's correct.
Okay, so there's no surprise.
All right, that was pretty easy. Vicky Breland, show me what you produced.
I think it's what has been proved. Has there been anything?
What's in the witness list?
It's what's on the witness list, Your Honor.
It's not looking good.
There were no written statements from her.
It's not just written statements.
There was no.
You practiced law here for 20 years. You know this.
Oh, you practiced law here for 20 years. You know this.
You have to turn it over. So if Vicky Breland said, hey, I knew A, B, C, D, she doesn't necessarily have to write it down. You have to tell them about it. Y'all show me what you produced. Is there anything else that you produced other than what's on S1?
No.
James Daniel Ford. Show me what was produced other than James Daniel Ford.
It would be the same, Your Honor. There's no written statements or anything. It'd be.
What about oral statements? Did he give an oral statement that would be relevant?
I'm sorry. Your Honor, Dr. Clark talked to Heath Smiley, and that is in Dr. Clark's room. So that has been furnished.
When? What day was that furnished?
On the 6th, I believe, Your Honor.
September?
September 6th.
It was due in August.
17 days after the fourth discovery deadline, the court did?
Yeah, it wasn't a conversation I had with Heath Smiley. That has, we're just bringing it to the court's attention that those statements are in Dr. Clark interviewed Heath Smiley. I was not present.
BG. What was produced in relation to BG?
I guess the same thing that is on the
All right? SB, SR.
same thing, same thing.
Sheriff Higbee.
Same thing, Your Honor.
Tricia Gilbert.
It's gonna be the same thing.
Okay, let's take Tricia Gilbert. And I understand your investigation. It seems that you didn't do the discovery.
I did not do this list. I have not talked to these witnesses. These witnesses, I'm dealing with other witnesses in other part of it, so I'm not familiar.
Okay, so let me ask you this. even though the rule prohibits this, the court's gonna require two attorneys to respond to this, okay? So I'll let Ms. Todd take this, all right? Is that fair? Did Ms. Todd deal with these witnesses?
All right, we're gonna hear from Ms. Todd now.
Your Honor,
Hold on just a second. As to Tricia Gilbreath, what did you turn up?
Your Honor, during a session I had in the DA's office with Ms. Newman and Ryan Berry, I relayed to them that the oral statements that the teachers had made to me during that session. In fact, it was even referenced in their expert report, which we got last night at 6:30 p.m. Our
Mm,
expert
We'll get to
report,
that. We'll get to that.
yes, sir. Our expert
So what
report,
do you have, other than your word, that you gave these statements to the state?
well, Your Honor, I didn't record my conversations with the state, but I also told the state during the documents that she's talking about is my direct examination. They asked me if I had any written statements for any witnesses,
That's
and I
not
said,
what the rule says. Did you speak to Tricia Gilbreath?
briefly, Your Honor,
What did Tricia Gilbreath tell you she's going to testify to?
she's gonna testify to what exactly I told the state she was gonna testify to.
No, you tell me. I have to make
Yes, Your Honor.
I'm making a
She's
decision.
gonna testify that she was one of the last teachers that saw Carly on the day she left the courtroom, and that Carly did
Where's
not
that
seem
at?
angry.
Where's that?
Your Honor, I don't have the witness list in front of me, but I believe it says in the witness list.
oh, she's gonna march right up to the bench. Ooh,
Thank you, Your Honor.
not always a great idea. Usually you have to ask to approach.
Your Honor, in the witness list, it says that she will be regarding her personal knowledge and observations from Carly from the fall of 2023 to March 19th. Carly's behavior and demeanor during the fall of 2023 to March 19th, 2023, based on her personal knowledge of Carly's relationship with her mother, Carly's personality, and her relationship with Heath Smiley, and Carly's performance in her classroom. That's exactly what she's going to testify to.
It's in there,
And the
but
reason we took
late.
it back to the fall is it shows you what, that she's had Carly in her room for that long. She knows what she's like.
So what did she tell you that you intend to elicit?
I just intend to elicit that when Carly left the classroom that day, she did not notice anything that seemed Carly was upset, that Carly was angry, or that Carly had anything but a positive relationship with her mom.
Where is that?
It says that.
Your Honor, the state sent us the same stuff in their witness list. I had this conversation with the state in person, didn't feel the need to write it all out again.
Yeah, but that's not what the rules
You don't have
say.
any proof other than what you say as to Tricia Gilbreath,
I mean,
correct?
I could call Ryan Berry if I needed to, but no, Your Honor.
He's a lawyer, he's not a witness.
Well,
But if you feel the need to, I mean, I'm not gonna stop you, but that's not, how's that relevant? How's what you just said relevant? That she seemed fine when she left school?
Well, Your Honor, I think it goes to Carly's demeanor, Carly's personality, and it will go into what,
State have any objection to a teacher saying that she seemed fine when she left school that day?
I mean, if that's what she wants to elicit from that teacher, and that's her only testimony, that she seemed fine and she had a great relationship with her mother, we would love for them to call her as a witness.
We would love
Nothing other than that.
snark.
That's
Let's
right.
go to the next witness.
Okay.
Next witness.
Snark attack. Well, I like the way the judge is doing this, though. He's going to get the state to consent to all these witnesses, and then he doesn't have to exclude them because of their late exchange and perhaps improper synopsis of their testimonies.
Andrew Clark,
Going in reverse order. We'll go into expert section.
Sheer Higby, same thing.
Okay. Show the court what you turned over in relation to Sheriff.
The same thing that's listed here, that she anticipates that she'll testify regarding her personal observations in Carly from the fall of 2023 to March 19th of 2024, Carly's behavior and demeanor from the fall of 2023 to March 19th of 2024, her relationship with her mother, Carly's overall personality and performance in her classroom.
All right. What's she going to testify to about the relationship?
Exact same thing to what the other teacher will testify to.
Well, let's articulate it clearly.
Okay, to articulate it clearly, Your Honor, she'll be testifying to that she's known Carly and had Carly in her classroom for the better part of a year during the 2023-2024 school year. She saw Carly on the day of March 19th, that she has known Carly and her mom for quite some time, that Carly is a good student, a good kid, not a troublemaker, not a troubled kid, and that
That's a lot of character evidence for what particular perpetrator.
Your Honor, I think it goes to what the state will be trying to introduce as Carly having some troubled child with a history of violence, which is just not true.
State have any objection to the witness testifying that that witness told her that year, she saw her on that day, that she's a good student, a good kid, not a troublemaker, not a troubled kid?
I think the last part we would object to until after Ms. Gregg testifies, and then she can put on her character witnesses. But as far as her observations of Ms. Gregg on that day, that she was not, didn't seem in distress or abnormal, and that she had a good relationship with her mom, we do not object to that testimony, Your Honor.
All right. Court will allow that testimony and that testimony only.
There you go.
Character witness testimony. Who's the next witness on the list?
At the podium, she's the defense attorney.
The next
Anna.
witness on our list is SR, followed by BG. These witnesses are the same witnesses the state's going to call, and we're calling them for the same reasons, Your Honor.
So you didn't turn anything else over? No statements from the juvenile witnesses,
I
right?
haven't even spoken to SR. So
What about BG?
BG spoke to him briefly, but the testimony is the same thing that the state recorded in their interviews.
They are referring to them with initials because they are minors. Well done.
They won't be allowed to testify to anything other than what's in the state's interviews. As the court pointed you to the case law, there is no exception to the discovery requirement for the defendant just because they're listed in the discovery by the state. So you can't elicit anything that's not in their report.
Wasn't planning to.
All right, who's the next
She's
witness?
getting a little
The
snippy.
next witness is James Daniel Floyd.
All right, show me what you turned over in relation to Mr. James Daniel.
Your Honor, the only thing we're anticipating calling Mr. Floyd about is just what he saw on the day of the investigations. I have not had personal conversations with Mr. Floyd. He's just going to confirm the demeanor of Mr. Smiley during the investigations when the police were at the house.
How's that?
I think it will be relevant to the case in chief when we start talking about the investigation that's going on and cross-examination with the
Well, I
state.
thought you weren't, he's not testifying to the investigation. What's he going to testify to about the investigation?
Your Honor, I feel like talking about this now is somehow going to prejudice Carly with the jury, so I'd rather.
Ms. Todd, you can't hide evidence. You can't go to trial and then not know what the witness is going to say. This is basic 101 law. Mr. Kent, can you cite?
Wow, this is basic 101 law. Okay. She's got a point. But if this is what Mississippi law says, that you have to delineate every single thing that the defense witnesses are going to testify to, it's a little broad for my liking.
A single case, one, where a defendant got to go to trial.
Dr.
and
Barry
not
in the
tell what
house.
The other side's going to say.
I definitely agree. We have to turn over our evidence to you.
And we're late. We're real late. Who is James Gilbert? I'm sorry, what was the name of the witness?
James Daniel Floyd.
James Floyd,
Yeah, who's that?
Carly's maternal uncle.
Excluded.
Excluded.
That's excluded. That's excluded as a willful discovery violation. That statement right there, there's nothing that's been turned over of any substance. Excluded. Next witness.
Next witness is Vicki Breland, the maternal grandmother. And it's going to go to the statements she made, not to me, but to the statements she made to the expert witness, Dr. Clark, regarding the family's mental health history.
When was that turned over?
That was turned over on,
The
gosh,
third.
the 3rd, Your Honor. We got the state's expert witness report last night at 6 p.m.
Yeah, I mean, come on.
You complaining about the state's response rebuttal witness to your witness is a bit like a lady standing in the street holding a Christmas hand screaming she's hungry.
Wait a second, what is like a lady in the street holding a what and claiming what? Is this a Mississippi expression that I'm not familiar with? Hold on a second now. What's good for the goose, good for the gander. You're trying a 14-year-old, now 15-year-old in an adult court for murder. She's facing 2 life sentences. You know, in the interest of fairness, Your Honor, I don't know if these are court-appointed attorneys. They're public defenders. I found Caleb Coleman has a website. So sometimes in cases that are severe felony cases, murder cases, for example, where I live on Long Island, there are no felony murder qualified defense attorneys in Suffolk County, which is why Rex Heuermann has a court-appointed attorney, but he's an attorney that's in private practice. His name is Michael Brown, and he's a great defense attorney. So I don't know about these attorneys. They are public defenders if they're in private practice, and because it's such a serious case, they are appointed by the court, or if her family is paying for them. I do not know. But I got to hear this expression again.
You complaining about the state's response rebuttal witness to your witness is a bit like a lady standing in the street holding a Christmas hand screaming she's hungry. You were ordered to turn over an expert witness July
Christmas
28th.
ham and claiming she's
Told me it was
hungry.
July 22nd. After the
lamp.
discovery deadline passed, we had a new expert witness was hired. So you juxtaposing what they've done with what you've done. Bottom line, what did you turn over to them? Show me what you turned over to them in relation to the grant.
The relationship would be the statements made to Dr. Clark, Your Honor.
That's in Dr. Clark's report.
And again, Your Honor,
All right.
both the state and the defense had to retain new experts after the discovery deadline was passed.
Well, now the state's expert was retained before.
The state's expert in being Dr.
Well, the state retained Dr. Gugliano. You instructed the defendant to plead to assert her Fifth Amendment rights during that conversation.
No, she didn't, Your Honor. She
It
didn't.
says so in Dr. Gugliano's report.
2-1 question.
And then I just got finished reading some of Dr. Pickett's report, and we're going to get to that. We're going to get to that. But let's stick with the grandmother and what she did. If you want to take shots at them on the expert witness, we'll do that. Show me what you turned over in relation to the grandmother before August 20th.
Your Honor, we didn't have anything for the grandmother before August 20th. That only occurred after the report we received from Dr. Clark, in which Dr. Clark spoke with the grandmother.
You're representing that you had no conversations with this defendant's grandmother.
Not to the nature of anything with the case. We have discussed the trial in general and explained the trial process, Your Honor. We have talked about how Carly's doing, but not anything that would go to testimony that she would put on at trial.
All right. Before we move on from that one, I want to hear a response from the state. Does the state have had the opportunity to speak with?
Your Honor, no, and I'm looking at Dr. Clark's report. There's no mention of an interview or discussion with Vicki Breland. If they could point me to where in the report it says he relied upon
Dr. Clark's report, you have a copy of Dr. Clark's report.
I don't have it with me, Your Honor, but he did have a
Let's go
conversation with Ms.
Go get it.
He can't. It's hearsay, Dr. Berry.
Move on to the next.
I mean,
I can't talk about Dr. Clark's report if you don't have a copy.
would you like me to proceed with Mr. Smiley until we can?
Sure.
Same thing with Heath Smiley. He has given a statement in which was listed in Dr. Clark's report as a 90-minute Zoom conference call. He has done a witness interview, which we received from the state, and several just with the body camera footage of things that happened on March 19th. That's what we're calling him to talk about.
Heath Smiley's testimony will be limited to the matters turned over for August 20th.
Your Honor, I would also cite that Mr. Smiley testified before this court, and we have that transcript on June 4th. The state has that, so we intend to elicit the same testimony at trial that we elicited on June 4th.
You're allowed to do that, so before August 20th.
Perfect.
So before August 20th. All right, is that everybody on the list?
Yes, Your Honor.
All right, if you would return the court's exhibit. And while we move to Mr. Camp, I assume you're handling the expert witnesses. Is that what's your?
Yes, Your Honor.
All right, Ms. Todd, I think your office is across the street. Can you go get a copy of Dr. Clark's report?
Well, if the state has it, I can reference it right
Yeah,
here.
mine has writing on it, Your Honor. I don't have a clean copy of their
I need a clean copy of Dr. Clark's report.
Oh, he's mad, Charisti. He's mad. Could be an appeal for ineffective counsel.
That's not his report.
It's hard for us to proceed without a copy of the report. Y'all need a few minutes to get a copy.
Yes, I didn't bring a copy of his report with me today.
I can't really address what grandmother-
You're having a motions hearing. You kind of need your file.
without seeing Dr. Clark. So let's take is there another motion we can handle while somebody gets a copy of them? Either one. There's two lawyers. I don't
Can you get a
care.
copy?
Yeah.
Okay.
But Your Honor, I don't think the state, I don't think the court has yet ruled on the state's motions that we did timely file, in which we also asked that the state not be allowed to make speaking objections. We also asked that the state,
I didn't see that. I did rule on the speaking objections.
Your Honor, our motions were so good, they filed the same minutes. As to the
They're
speaking
great.
objection. and-
Thank you, Your
They're
Honor.
granted. I didn't see those. They're granted. Do we have any other motions we can hear before somebody can get me a copy of Dr. Clark?
We can do we have our cursory motion to move it down to the youth court that we filed sometime before.
I'll be happy to hear that. Can we work on getting Dr. Clark's report? Somebody. Anybody?
Yeah.
Your Honor, may I address briefly the substance and just cite the court to the attachment that I filed, which shows that we were missing each statement, the teacher's names and substance of their testimony, Dr. Webb's report, and potentially a journal of Ashley. That was on August the 20th when we signed for it. So they knew at that time that we did not have the teacher's names or the substance of their testimony.
Is there an alleged journal of Ashley Smiley?
We do not have a journal of Ashley Smiley.
Does anybody have an alleged journal of Ashley Smiley?
I don't think my understanding, we don't have it. We do not have
Where
it.
did that come from in Dr. Pickett's report? I've been able to read about 17 pages of Dr. Pickett's report. He references a journal of Ashley Smiley. Who gave him, I don't think Dr. Pickett just made up a journal, did he?
We didn't provide Dr. Pickett with anything. So if he's, that would have been something that the state gave him. That's not.
All right, let's take a 15-minute recess. Y'all go get Dr. Clark.
He needs to put himself in a timeout.
15-minute recess.
They're talking about the mom's journal. Like somebody had a journal of Ashley. Ashley is the mom. We are behind, so we may fast forward to real time. These attorneys are failing her, in my opinion. This is a problem. I mean, discovery deadlines are real. I don't know how many other cases you have, and quite honestly, I don't know how many other cases you could have while you're working on this case. But somebody said they just came over from Law and Crime Chat. Law and Crime Chat loves this judge, and we seem to have. Listen, I did like the judge in his pretrial. I thought he was fair. I thought he was all about it seemed to me like he wanted her to get out of there. That's why he's pushing this trial so quickly. You guys, it's only 6 months since these killings took place. And we're already moving to trial next week. When's the last time you saw a trial that quickly? And a lot of us thought it was because he really wanted to get to the truth of Carly and what caused her to kill her mother, lay in wait for her stepfather. Thank you, Mama Shea. Judge Dewey is the judge, Daddy. I don't know. Do we still feel that way? Harmony said, in my opinion, the judge is irritated because these lawyers are failing their client. That's kind of like, I was kind of getting that vibe too. I mean, he's not putting up with any of it. If this judge was sitting on the Karen Reed case, that case would have been tried. None of Lally's witnesses would have been allowed in. Talk about fluff. Shock and horror. Thank you. I'm just a girl in the world. Fia super sticker. This is a rough one, you guys. I don't know. I want to know where you guys are on this. I still don't know where I am on this case yet. Debbie says, I don't have a problem with the judges making the defense do what they should do or should have done. Yeah, I mean, there are rules in place for a reason, right? Gail says it's embarrassing. Yeah. Yeah, on the other hand, maybe the Karen Reed case would have been tried if Judge Dewey K. Arthur was sitting in Dedham. Maybe that's it. Right? Is there any way that the judge can take these guys out and give her another set of attorneys, Linda Lane wants to know. Not likely. Happened in Delphi, though, didn't it? That's a different state. That's Indiana. You think the lawyers are covering for the witnesses? I mean, first of all, how odd is it that there's so many family members that want to come in and testify for Carly to get her off? Especially the mother of her mother, whom she killed. Something's going on here. Something's not adding up. I have so many questions. Nellie says this judge is penalizing the 14-year-old for her lawyer's failures. She has no control and likely no understanding of procedures. This is BS. Yeah, I'm so torn. Pilgrim Shadow's opinion is premeditated murder and attempted murder not insane. She shouldn't be tried as an adult, though. Mistrial. If defense needed more time, they should have waived speedy trial. Great point. Martha says it sounds like the defense attorneys have never worked on a murder case. I don't know. Have they? I've got Caleb Coleman's bio here. I don't really know if he still works for this firm, but we can take a look at it. Let's take a look at it while we're here. Caleb is a native of Madison County, Mississippi. He received his, does he still work for this firm? I don't know, because there's another website with his own name on it, like his own firm. Received his BBA degree in managerial finance with emphasis in investment analysis from the University of Mississippi. Graduated cum laude from the University of Mississippi School of Law, where he was awarded some awards, blah, 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 blah. He edited some family law treatise. It doesn't say here what kind of law he practiced. So let me go back there for a second and then came it. Well, I don't know. Here's a Caleb Coleman and Associates, and I don't know if this is him, but it says they're personal injury lawyers. Nothing against personal injury lawyers, but they don't try murder cases.
All right, we're gonna
And I don't know
move
if this is him.
particular to the
Go back.
state's motion to exclude, for lack of a better term, the expert witnesses. All right, as I appreciate it, state wishes to exclude the report of Dr. Gerald O'Brien, is that correct?
That's correct, Your
All
Honor.
right, defense doesn't have a report for Gerald O'Brien,
Don't
correct?
have
That is correct, Your
All right, so you confess that, correct?
Honor. There has never been a report.
State wants to exclude the report of Dr. Mark Webb, is that correct?
That's correct, Your Honor.
There's no report of Dr. Webb, is that correct?
That is
No,
correct.
So you confess as to Dr. Webb.
Yes, Your Honor.
Let's move to, is it Andrew Clark?
Yes, Your Honor. Yes, sir.
All right, does anybody have a copy of Dr. Clark's report for me?
Yes, Your Honor.
Let's mark that, if you would. Ms. Newman, take a look at it. If y'all agree that's the report you received, let's mark it D1. D2, excuse me.
Sorry, Judge. Straight for a page, yeah. All right, so Frank on.
All right, this is the state's motion. I'll hear you out. Was there anybody else that we did not touch on?
No, sir.
So Dr. Clark, right?
That's correct.
Here you go.
May I proceed?
Yes.
Your Honor, the motion was actually filed on August the 30th, 2024, the deadline for motions for filing in this case. We, at the time, did not at all have a copy of the report from Dr. Clark. I think we were in possession of a CV, but that was it. We received on September the 3rd at 7:09 p.m., we received a forensic evaluation report from Dr. Clark. We still now maintain that his report should be excluded, not because we didn't have it, but because it does not apply the proper standard for insanity. It does not comply with McNaughton. And we believe that it's more prejudicial than probative and would confuse the jury as to issues, which leads to why we do not think that they should be entitled to mention an insanity defense or insanity. His opinion, again, does not cover the McNaughton standard. It appears to cover a diminished capacity standard, which the state of Mississippi does not recognize. In addition,
Where is this? I was just seeing the report called, where in the report is this?
he has a summary opinion, Your Honor, on page 24, the very last paragraph of that page.
I apologize for interrupting.
That's right, Your Honor. We believe that that opinion is in reference to a diminished capacity standard upon which the state of Mississippi does not recognize. In our motion, we asked for a Daubert hearing. I do not see Mr. Clark in appearance. I don't know what he looks like, but I asked defense counsel if they intended to have him here before trial, and I was told he was not going to be here. So again, all we have to rely upon is his report, where in fact he does not cite to the proper standard for McNaughton. There are plenty of cases within this state that have excluded similar testimony when it is confusing to the jury. And again, this might be proper for something at sentencing, if I don't want to put the cart before the horse, but if the jury were to find her guilty when the state then requests for a sentencing of life, this might be appropriate for that, but it is not appropriate for comment in front of the jury at any time prior to that. And again, our motion essentially talked about Daubert and the standard. Again, he should be excluded under 702 because his opinion does not reference the proper legal standard in the state of Mississippi.
Anything further?
No, sir, Your Honor.
Response.
Yeah, if they're arguing that they wanted a Daubert motion, in their motion that they filed, what they're saying is that they did not have a report. And so based upon not having a report, that there weren't any foundations or anything laid at that point. The report was given to them on September 3rd. There has not been an amended issue on this. We have not been put on notice or anything that his report did not suffice them to say that he's arguing McNaughton. He is arguing McNaughton. That is the whole thing that we have talked about. It is not diminished capacity. It is McNaughton. It's what his argument has always been, and that's what we intend to put on if he's our expert.
All right, let me ask this, and you're saying you have been put on notice about their argument. But their defense, how can they file a motion on something they don't have?
Your Honor, I agree. We provided that as soon as we got it. We turned around the same day that we got the report. We gave it to them. In fact, I think Dr. Clark did his evaluation on Thursday, and then within a few days had his report, and we provided it to them. That was done as quickly as we possibly could. And I just sort of want to point out, both sides had to get different doctors. Dr. Guglio was the initial person that was supposed to do both the McNaughton and the competency. And then she was not able to do the McNaughton, and so you had to get a separate doctor that then he went and did the McNaughton part for the state. So both sides have had the same issue.
Hang on, as I recall, Dr. Gugliana basically stopped the interview once she asked the defendant whether or not she had ever abused prescription medication, and she basically said, I'm going to plead the fifth to that. She said, I can't testify as to prescription issues. I'm not a psychiatrist. I mean, had the state been provided evidence, not what somebody says. We're lawyers, we're not witnesses, right? They could have gone a different direction. They're both late, okay? They're both late. You want me to exclude them both?
Well, I think both of them have to come in, Your Honor, and part of this is not again, most of the case law was talking about if it's, obviously, I think the court says this is not intentional on either side. This is just dealing with psychological issues, and we had to reevaluate, right at the end. Both of us had to get new experts. Both of us were jumping through hoops to make that happen. We've provided a report. They've provided a report. There's not surprise. There's the trials next Monday is when that's set for. That's the main issue is if this stuff is coming in, if we're giving you, or either side's giving reports right at the last minute, that's what the court sort of is addressing as far as excluding all this information and stuff. And that's not what the intent is. We tried to move heaven and earth to get the new expert down here, get him to do an evaluation and get the report done. And we think the report suffices, and it is definitely not diminished capacity is what we're arguing, Your Honor.
Okay, well, let's nail this down. Are you arguing automatism by way of involuntary intoxication? Or are you arguing McNaughton?
We're arguing McNaughton, Your Honor.
So you're not arguing automatism by way of involuntary intoxication?
We're not saying voluntary intoxication.
Involuntary.
We're not saying involuntary intoxication. We're saying that there in the report there's a whole bunch of different issues that are going on, and that's what impacts her ability to make the determination between right and wrong. And that's in a summary at the very end.
All right. With this having been turned over late, if Dr. Clark is available by Zoom to speak to Heath Smiley, he should be available by Zoom to speak to the state investigation.
I don't have a problem with that at all, Your Honor. In fact, I was surprised that didn't happen with Dr. Pickett.
Well, again, I made my analogy about you complaining about Dr. Pickett. Dr. Pickett turned over the report in 7 days proceeding. So you're not on good footing. How about that? All right, anything further?
No, Your Honor.
All right, reply by the state.
For clarification, we have permission to talk to Dr. Clark
That's
about,
what I'm getting to.
Okay. Sorry.
All right, by way of reply, let's start here. What's the state's objection to you being able to speak to Dr. Clark even if it's by Zoom or whatever, in order to try to alleviate delayed discovery.
Yeah, Your Honor, so in our initial motion, we requested a Daubert hearing and further order compelling them to provide the materials that they provided to the expert. So again, we don't have any 90-minute, he says that he relied upon a 90-minute Zoom interview with Heath Smiley, as well as a 4-hour interview with Carly Gregg. I mean, I think we would certainly love to talk to him about what disclosures were made during that, but I think this court has ruled already that Heath Smiley will be limited to his testimony prior to August the 20th and in court. But I still think that there's some things we need to ask. The state still would like a proper Daubert. We do not believe that his opinions meet the standard, and would request that we have a Daubert hearing prior to voir dire, Judge. We don't think that
Good.
that's
Do it.
fair for us to have to voir dire on an issue, not knowing whether the insanity defense would even be argued.
Fair.
Respectful
Compromise. Hold a hearing.
Objection to the court granting you time at a Zoom meeting. However, when you discuss this with Dr. Clark, what's the objection to that?
No objection, Your Honor. If he's willing to talk to us candidly.
Sometimes as a defendant, you don't want your expert to render a report because it's discoverable. We saw that in Karen Reed too. There were some experts who did not render reports. It's not uncommon. Maybe it was Ashley
Anything
Benefield I'm
else
thinking of.
in Dr. Clark's report that you've not received?
Court's indulgent. I'm not sure. He may can clear this up. Pages of Carly's diary. It's been my understanding that there's some other diary out there that we don't have. And of course, if the defendant doesn't intend to introduce it into evidence, we might not be entitled to that. However, if he relied upon that, we certainly would want to know which diary he's talking about, the ones that were produced by the state in evidence or the ones that are in the custody of the defendant.
I'm completely lost here. First of all, how does anybody intend to get a diary? You know, that's Hornbook law, that a diary is.
Hornbook law. That takes me back to law school.
First day, second year of law school evidence class. How do you propose that you want to get a diary into evidence?
Of the defendant? Her own statements?
Okay.
It's like, yeah, never mind.
Yes, sir.
All right, so all you have is a diary of the defendant, Carly Gregg, correct?
So Your Honor, we produce some of Carly's diaries in evidence. Law enforcement sees some. It's our understanding that the defense is also in possession of some additional diaries that they took out of the home after law enforcement left. And
Does the
granted,
defense have some diaries they intend to, that they gave to Dr. Clark?
No, Your Honor, everything that was given to Dr. Clark was from the state's discovery.
Okay, so it is only the defendant, Carly Gregg's diaries, correct?
if that's what they're saying, the pages that were produced in discovery, if that's all he relied upon, that's fine. We just wanted to make sure that we know what he's relying upon. Yes, sir.
So there's no other diaries by the state?
No.
By the defense?
No,
All right, so there's no diary of Ashley Smiley by the state?
The state did not produce a diary of Ashley Smiley. The defense emailed Dr. Pickett on August the 22nd, a typed, what they had labeled journal of Ashley Smiley, and that's what Dr. Pickett was relying upon in his report.
Does the defense have some purported diary of Ashley Smiley?
Your Honor, it's a visitation log that I labeled journal, but it was turned over the day I received it to both Dr. Pickett and Ms. Newman. It was CC'd on the email. So the day I got it in my possession to send to Dr. Pickett, it was sent to the state.
And Your Honor, I apologize for talking over. We are in receipt of that. We're not alleging that we're not.
Whose journal is this?
Allegedly, Ashley Smiley's.
Where did you receive Ashley Smiley's journal?
Your Honor, it was in a packet that packet that the family brought to me that had divorce proceedings and those type documents in there. It's a visitation log that she kept that had various issues written in there.
A visitation
So
log.
the day I received it and found it, I gave it to the state and Dr. Pickett, the state's expert.
We have an expert relying on unauthentical.
Unauthentical.
Hearsay is not able to be authenticated. Double hearsay that can't be authenticated.
Kinda, yeah. Well, she's dead. Yeah, it was the mom's, her like visitation log. She must have kept notes on them.
Anything else?
And again, we'd ask that we be allowed to have a on-the-record Daubert hearing of Dr. Clark prior to
Where's
voir
Kevin
dire
Camp?
in this case.
Mr. Camp, is there an objection?
You're right.
State having
Okay,
adult
strike
hearing.
everything that I said about
If-
Caleb
if
Coleman.
they-
Who the hell's Caleb Coleman and why is he in my notes? Why is he invading my notes? Was he a different attorney that she had at one time? I'm so sorry, Pamela Fisher, for coming in. Thank you for coming in with the right information. Her attorney's name is Kevin Camp. I don't know how my notes say that, but it is Bridget Todd as well, right? Okay, Kevin Camp. Do we know if he's a public defender or private? Although that picture that I pulled up before kind of did look like him. All right, thank you.
I guess after talking with Dr. Clark, if they still want to do that, I don't have any objection to doing a Daubert hearing if they need it. Hopefully it can be resolved by them talking with Dr. Clark to clarify that he is doing McNaughton. If he's doing McNaughton, I think that answers their question for him. It's not diminished capacity.
All right, anything further from the state?
Yes, sir, Your Honor, that Dr. Clark not be able to amend his findings subsequent to our conversation.
All right. Court is looking at Rule 17.2, Rule 17.3, and Rule 17.4. There's no argument that the defendant requested rule evidence, that requested discovery under Rule 17. The fact witnesses in this case that were proposed are wholly different than the expert in this court's view. I believe I understand what happened with Dr. Webb. The defense can't help but I don't think Dr. Webb was able to give you what you need or what you wanted. You're put in a scrambling position. So you obtained an expert who got it pretty quick. However, the state's right. There are things where he wants, these experts are relying on double hearsay that can't be authenticated. Now, experts can rely on some hearsay, but you have to be able to prove some reliability. I have to be frank, a journal that miraculously appears at the 11th hour is suspect. This is what the court's going to do. Today is September 10th. If the defense intends for Dr. Clark to testify, you need to arrange sometime tomorrow that a Zoom conference can be held. So the state can question Dr. Clark. We will meet back here Friday morning, the 13th. And we will have a hearing. If the state wishes to exclude part of it, file a written motion. If you still believe that it is diminished capacity, we'll look at it. This case follows the state follows 250-year-old law in regards to insanity. I believe it is a very wise decision that we continue to follow that 250-year law. It has stood the test of time. This court is not going to be a trailblazer. However, there will most likely be, I'm not putting the cart before the horse, but if the jury does not acquit her, there will be a sentencing phase. I expect diminished capacity can be used in the sentencing phase. So while diminished capacity may not be necessarily admissible during the guilt phase, it would be admissible during the sentencing phase. And Dr. Clark be here for a dog hearing if necessary on the 13th. To the defense.
If needed, Your Honor, we can get in here.
Okay? All right. This is what the court is looking at. The court found there was a discovery violation. However, as Dr. Clark, the court is not inclined to exclude the witness at this time. The court is looking at Rule 17.4, the effect of failure to comply. A, granting a continuance or assessing costs against the appropriate attorney or party. I'll just be quite frank, Mr. Camp, I've known you for 20 years. I don't intend to assess you with costs at this point in time. But I've never seen this from you. If I have to grant a continuance from the 16th, I can continue to the 23rd. But I'll address that on this Friday. But the court intends for the case to be tried this term.
Okay, so he's already talking
Second,
about perhaps putting the trial over for a week or more, but he said this term, he wants to schedule it this term. He's already wavering in his come hell or high water September 16th trial date. That's a good thing. That's a good thing if it lets the state talk to these expert witnesses and allows this child, because she is a child, to have a defense of insanity because she needs these expert witnesses to do so. That is the right and just thing to do. And he just said, I have known you, Mr. Camp, for 20 years. What she's also saying is like, dude, you know better. I've known you for 20 years. You don't drop the ball like this, usually. And I've never sanctioned you with a money fine because that's what they can do. It's another remedy. Instead of excluding the witness, they can make the lawyer pay a sanction of $1,000 or something. He says, I've never done that with you, and I'm not inclined to do it now.
limiting further discovery of the party failing to comply. This is it. No amendment of Dr. Clark's rule. We're going to ride the horse we brought.
We're going to ride the horse we brought.
Finding the attorney failing to comply and contempt, or excluding the testimony of appropriate witnesses. And we do offenses. All right, the court went over S1. The court looked at it. For example, Vicky Breeden is a witness closely identified with the defendant. The late disclosure, this court, that's what this court has a problem with a witness closely identified with the defendant. What is provided is not the substance of her testimony. Same with James Daniel Floyd.
These are both
What we're
relatives.
concerned with is not a listing of witnesses. Nowhere in the rules does it say provide a list of witnesses. It says provide the name, the address, the substance of the testimony, written, recorded, or oral otherwise. When I look at Vicky Breeden and James Floyd, Shara Higby, Tricia Gilbert, those are witnesses closely identified with the defense. For those reasons, the court stands by its prior ruling. Heath Smiley. Mr. Smiley has made it very clear that he wishes to stand with the defendant. That's a witness, closely identified with the defense. It will be limited to everything he's testified to before or the statements previously provided by the state. As to Dr. Andrew Clark, the court is going to delay its decision, allow the state time to interview the witness, prepare any objections that need to be made or conduct a discovery. The court believes that's a fair way to allow the defendant to put forward her evidence, whether it be in sentencing or in the guilt phase. But that's going to be the court's ruling right now. We will reconvene here this Friday, the 6th, at 9 a.m. I expect at that time for the state to announce either you're prepared to proceed or we're not prepared to proceed. If you're not prepared to proceed, why are you not prepared to proceed? And what in particular will you need to proceed? All right. The second thing the court will be looking at is a Dahlberg style hearing, if required. We'll be looking at, is this diminished capacity evidence, or is this McNaughton evidence? And I'll hear arguments as to why it's diminished capacity or why it's McNaughton at the time. All right, is there anything I've made clear for the state?
All right, just to be clear, the Friday the 13th, right, this Friday?
Yeah, I'm sorry, I said Friday the 6th.
Yes.
Friday the 13th.
Thank
Excuse me. Worst I can imagine how to hear. Friday the 13th. All right. Is there anything I've been clear on, Mr. McCann?
No, Your Honor.
All right. Were there any other motions by the state?
Court's indulgence.
Court's indulgence. I'm sure the stepfather is there on her behalf. The whole family has been there throughout every hearing. Somebody asked if it's untreated. It's not untreated mental illness because she was on some kind of Lexapro and they talk a lot about having changed her meds in the weeks leading up to these murders. So we don't really know a lot about what her mental health issues are, but I do not believe it was untreated like it is in the Colorado case.
Your Honor.
All right. By the defense. Any further motion?
Right.
No, sir, Your Honor.
All right. By the defense. Any further motions? Did you want to argue the motion to transfer to youth court now?
Your Honor, I would, if I'll go to the podium. We have filed our motion. We think that it would be in Carly's best interest, it'd be in the best interest of justice. We filed the motion some time ago. We know we have a trial date coming up, but we'd ask the court if we could transfer the case to youth court in the interest of justice.
Response by the state other than your written response.
Our written response, Your Honor, and just for judicial notice, the youth court prosecutor, Corey Garber, is still present in the courtroom. Just would like to, if the court would like to hear from him on whether or not the youth court would be interested in entertaining his grandmother.
It's your motion. Do you want to call the witness or not?
It's not my motion, Your Honor, it's the defendant's motion.
That's your response.
Oh, sure.
If you want to call, I might call.
Sure, Your Honor. The state calls Corey Garber.
Oh, he's the prosecutor in the juvenile court. Okay. He testified before. He was very smiley. Yep. She had recently switched from one kind of antidepressant to another. All right, let's see what he's got to say. No, we don't want this case at all. We do not want this case.
Mr. Garber, I believe back in June of this year, my office contacted the youth court and sent y'all a copy of the motion and possibly our response in opposition to the defendant's motion to transfer to youth court. As a representative of the youth court, did you have an opinion on whether or not the youth court is the appropriate venue or jurisdiction for Carly Gregg, who's been charged with murder, attempted murder, and tampering with physical evidence?
Under the rules, under the statute, youth court should only be handling cases where there's a reasonable prospect of rehabilitation. I have not followed this case, but I'm unaware of any reasonable prospect of rehabilitation.
BS. BS, you have not followed this. Are you kidding me? This is the biggest case in Mississippi right now. You guys can correct me if I'm wrong. That my freeze game is on point today, you guys. I have not been following this case. But is he going to sit here and tell us that he does not think she can be rehabilitated? Based on what? Based on him just sitting in the courtroom today? I call BS on this. No way, dude. Hold on.
Under the rules, under the statute, youth court should only be handling cases where there's a reasonable prospect of rehabilitation. I have not followed this case, but I'm unaware of any reasonable prospect of rehabilitation in the juvenile justice system for someone who has committed the crimes which you just listed.
No further questions, Your Honor.
Cross-examination.
Corey, if the individual, I guess, had some mental issues and things like that, there are, I guess, different avenues that the youth court could follow, correct?
I'm going to need you to clarify your question.
You have, I guess you have counselors and you have people that could come in and see her, correct?
We do have counselors. So Region 8 has a counselor on staff at the Juvenile Detention Center who visits with children who are detained there, yes.
And right now where Carly's at is she's in solitary confinement because she has no, I mean, she's in the adult jail. She doesn't get to, she has to be housed separately. So for this entire time, she is in solitary confinement.
Yeah.
She didn't get to interact with any of her other people her age or anything like that. If she was at the youth court and at the youth detention center, would she be able to interact with people her own age?
And she would be isolated. It's like sound separation. She is considered to be an adult. It's fairly clear that under the federal rule that anybody charged as an adult cannot be held and detained the same as a juvenile. When she was detained at the juvenile detention center, she was kept separate from the juveniles there, so she would still be kept separated.
Well, this would be if it's sent back. If she's sent back, she would be a ward of the youth court at that point.
Oh, if you're saying that the case is transferred back and
Yes.
Yeah, I mean, at that point, she would be considered a juvenile, yes.
Right, and she could interact with people her own age.
Sure.
She could be getting counseling. She could be getting things of that nature. What about her schooling? She would be able to be doing schooling, correct?
She would.
Right. Right now, she has no access to schooling whatsoever. So there are actually programs and benefits about going back to the youth court, wouldn't there?
Mr. Camp, I want to clarify. If she were adjudicated in the youth court, these would be the dispositional alternatives. One would be 90 days in detention. So for 90 days, not counting the amount of time that she's already spent detained pre-trial. So
If you're not looking at the screen, and we're not watching the witness right now, although he does have a nice voice, we are watching Carly Gregg break down, and it looks like she's crying, although I'm sure there are some people out there that are going to say there are no real tears, but my freeze game again is on point because her face is just breaking my heart. Like, she just looks like a baby to me. I have 5 kids of my own, and 14 is a baby. I don't care what anybody says. And she did a horrific, unforgivable thing. But for this man to sit up there and say that there's no chance of rehabilitation, she's 14. I don't know if I'm buying it. Are you? I don't know where I stand on this case yet. And I guess that's the way it should be, but I'm really conflicted.
The idea, the meaning behind the statute would be the intent that she can only be detained for 90 days. So it would be my understanding she would possibly have to be released upon being transferred back because she's already exceeded the 90 days that would be considered for disposition. Secondly, the other alternative would be Oakley Youth Developmental Center. The average stay at Oakley is 6 months, 6 to 9 months, to which she would be released on parole, all of which she could receive some type of counseling. Yes, the question is going to be, is that counseling is Oakley Developmental Center or is the 90-day stay in the juvenile detention center enough to rehabilitate for purposes of the acts that are alleged? My opinion is no.
Now, she could get some help though, correct? That's the only, right now, she's not getting any, I guess she's seeing a counselor through Region 8, but there's no schooling. There's no long-term counseling, but you have long-term counseling at Oakley, correct?
Long-term counseling, again, it would be 6 to 9 months. Should she be found guilty in this court, she would have available to her all of the resources that are available to anyone at the youthful offender unit, which would include possibly education and the like. She would have the adult services that are allowed. The question though is, could she be rehabilitated in the juvenile justice system? I don't, again, haven't followed her case. I don't have a social summary in front of me. I'm not prepared to make that decision other than based on the allegations of the crime. And those types of things are also considered. It's an A through N survey, and the first 6 or 7 factors of that are going to be the nature of the offense committed. That's a lot to be taken into consideration. If we're talking about charge of murder and attempted murder, those are going to be very difficult to rehabilitate in the juvenile justice system. It's just not built for that.
No further questions, sir.
Reader.
No, you're your turn.
Stand down. It's a little harsh.
Nothing further, Your Honor.
Any witnesses in reply by the defense?
No, Your Honor.
All right, any further argument by the state?
Your Honor, none other than what's already in our motion, our response.
Any reply by the defense?
No, Your Honor.
Court's going to deny the motion to transfer the defendant to youth court. I appreciate Mr. Gerber's testimony.
Denied.
The court was very familiar with the inherent limitations of the youth court. That's not a knock on the Rankin County Youth Court by any means, but as this court appreciates it, me transferring this case back basically is an acquittal. I don't think that's an appropriate ruling for a court to make. I believe in juries. And that's what's going to happen in this case. The jury,
You lost the
this
mic.
community is going to make the decision whether or not to acquit her, whether or not the homicide is justifiable or excusable, or whether or not the state can prove that beyond a reasonable doubt. Those are not questions for a judge. That is a question for the jury. This court will not stand in the way of the jury. All right. State's giving an order denying the motion transfer back to youth court. All right. We'll
You know, sometimes when this judge talks, I really feel like he feels like she's going to be acquitted. I don't know. It's like my instinct, my intuition is just telling me that the things that he says and the words that he chooses, you know, he's like, well, I want a jury in this court to decide whether or not she was justifiable in what she did, or whether or not she had an excuse for what she did. And the way that he says it, it's just giving me that vibe. Do you guys getting that vibe too?
reconvene here this Friday morning, September 13th, unless I receive an order from the state that no motions are necessary and you're prepared to proceed to trial, or notification to that effect, all right? We'll be back here this Friday morning, September 13th at 9 a.m. Then it will remain in custody. See y'all back there.
And Your Honor, we have one issue that we'd like to take up in chamber with you, if we could.
Yeah, I don't know. I was just getting that vibe. Some people are saying no, they didn't get that vibe. Let's just rewind it. I just want to hear that last little thing that the judge said about, you know, whether I want the jury to decide whether or not she's justified. So hang on a second. You're going to have to turn the volume up on your own because he lost the mic all of a sudden. Here we go.
The motion to transfer the defendant to youth court. I appreciate Mr. Gerber's testimony, but the court was very familiar with the inherent limitations of the youth court. That's not a knock on the Rankin County Youth Court by any means, but as this court appreciates it,
He's aware of the limitations of the youth court. It's not a knock on the youth court by any means.
me transferring this case back basically is an acquittal. I don't think that's an appropriate ruling for a court to make. I believe in juries. And that's what's gonna
Oh, they have no juries in juvenile court. He said, I don't believe that it's an appropriate decision for a court to make. I believe in juries. That's the difference.
happen in this case. The jury of this community is going to make the decision whether or not to acquit her, whether or not the homicide is justified.
Whether or not to acquit her, not whether or not to find her guilty. Notice his choice of words, and I say this all the time. Lawyers and politicians, but especially lawyers, choose their words very carefully. This judge is obviously also a lawyer. Whether or not to acquit her.
whether or not the homicide is justifiable or excusable, or whether or not the state can prove that beyond a reasonable.
Whether the homicide was justifiable or excusable, or whether the state can prove that. Sorry, I'd just like to repeat it to you because I know the volume is really low and some people freak out, they can't hear it.
Now, those are not questions for a judge. That is a question for the jury. This court will not stand in the way of the jury. All right.
He won't
State's
stand
in-
in the way of the jury. Maybe he did exclude two of the witnesses. He excluded the uncle and the grandmother who, I mean, really, quite honestly, it's no surprise to the state. They've been there for every single hearing. The state knows that her family has been supportive of her, that they've been showing up, that the stepfather wants her bail lowered, that they want her to be able to be free, that the stepfather's going to get up there and say he doesn't think she belongs in prison, right? It's not really a surprise. So that was kind of the vibe I was getting from this judge, that he thinks that the jury in this community, her mother allegedly was a beloved math teacher in the community, could go both ways. But if a jury sees all the familial support that she has, and now he may be having a Dalbert hearing on Friday. We'll have to come back Friday the 13th for this hearing in the morning. The Dalbert hearing on the expert, Dr. Clark, finding a way to let the experts in. We don't really know what the experts are going to say. That's the thing. He knows more than we do, but really not a lot because the defense was negligent in their disclosure of discovery and did not provide a synopsis of what the witnesses were going to testify to, or at least just some sort of substance of their testimony. They didn't do it for the grandmother and for the uncle, so they've been excluded. But the stepfather is going to be allowed to testify, and once he gets up on the stand and he's testifying for the defense, the jury may say, this girl was really, really ill. She's really mentally ill. The family knew, perhaps, and they may acquit her. And I that's just the vibe I'm getting from this judge. That's my opinion. And I'm sticking to it for now. Thanks, Angela, for becoming a new member. And thank you, Cat Artist, for your super sticker so very much. So very kind and generous, as you always are, all of you who watch and tune in to this channel. And thank you, Ann Smith, for your matcha latte. And Wendy, darling, thank you so much for your matcha latte. And for the anonymous matcha latte buyer, thank you so much. And for Cherry, who sent the Venmo, thank you so very much. And to all of you who are in here today, keeping the chat classy. It's been a long day. We did a long stream this morning on the Boulder supermarket shooting, which is a horrific case out of Boulder, Colorado, where I went to college, Go Buffs. And 10 people were killed in a King supermarket back in March of 2021. And there's also an insanity plea in this case. Both states follow the McNaughton rule, which is a rule that goes all the way back to the 1800s. It's like the King's rule. And under the McNaughton rule, it's M'*NAUGHTON. And since we're here, and I found a slide on it, I think somewhere. Well, the slide just went away as soon as I tried to show it on the screen. So hold on. The MNAUGHTEN. Let's just put it up here real fast because a lot of you have been asking. Each state is, as you know, the maker of its own laws. And coincidentally, both Colorado and Mississippi follow the McNaughton rule. So let's just take a quick look at a slide. Get rid of this. Stop that. Present this. Share this. Here's a little graphic for you. To establish insanity. Oh, well, that's here. The legal definition. You think something's going to be easy and it's not. These are more like the facts of the case. So here's the McNaughton rule, which is sometimes spelled McNaughton, was the first legal test for criminal insanity. The test originated in 1843 in England during the case against Daniel McNaughton, hence the name. McNaughton shot and killed the secretary to the prime minister. So this goes all the way back to the King's rule. And are they even going to tell us what it is? Come on, man. Come on, man. Cornell Law School, get it together. What's the test? In simple terms. Should a person who commits a crime be unable to recognize that the crime is morally or legally wrong due to mental disease or mental defect, they should be found not guilty by reason of insanity. There are two prongs. That at the time, all defendants are presumed to be sane unless they can prove that at the time of committing the criminal act, the defendant's state of mind caused them to, 1, not know what they were doing when they committed said act, or 2, that they knew what they were doing, but did not know that it was wrong. That is the standard of proof for the McNaughton rule. And there you go. Look at Mel Stiller. I beat you to it. Same as in Colorado. So that answers both questions for both of the cases that we are currently covering. Lisa, thank you so much for your super sticker. And to everyone, thanks so much for keeping in the chat classy today. To my moderators who work harder than anybody else on YouTube, thank you so much. As always, tomorrow we will come back and cover some more of the Boulder shooting case, which has been tragic, but a very necessary case in our opinion to keep watching and analyzing. So thank you so much for my moderators for keeping it classy, and to my members, viewers, replay viewers, please hit the like button on your way out because it really does help the algorithm. Make sure that you're subscribed. Feel free to share the stream out. Let your friends know where to come and watch it. Anybody who's in Boulder that wants to watch the Boulder trial in a safe place with a safe chat, invite your friends. Make sure you have the bell set to all notifications because I don't always have a schedule and I tend to go live just randomly like some other creators. So thank you so much. As I always say to end every stream, be cool, be kind, be classy, because it's not hard. It's really not hard. Peace, everyone. If you are going to watch the debate tonight, stay safe. Until next time.